You know what? May I just bring to Lordship notice that I just filed not to the to my point which I have raised. Lordship, keep it out.
Very well. Yes.
My Lord is asking the state of Madhya Pradesh to furnish that, but they are not furnishing. Then I was filed an application along with the so the IA number is 144720. This is a very important data.
Very well. We'll take that into account. Yes, sir.
Lord, may I continue?
Yes. Oh, yes. Sorry, Biju.
I'm sorry.
No. Yes, please go ahead.
Not because I'm EWS.
Yes.
My Lord, sir, with utmost respect to my Lord's court. Last time, my Lord, I indicated the very submissions of then the attorney, A.K. Venugopal sir, economic criteria, admission to private unaided colleges, and the extremely important point is exclusion. So, my first submission, I am getting my note, my Lord. I prepared a short note, and I will take only the time which my Lord granted to me. Well, the other side argued, if somebody touched 15.4, 15.5, 16.4, 16.5. Somebody taken away their rights. So therefore they argued exclusion. Actually, they included, like Venugopal sir submitted, there are compartments, the evolution of the constitution, with the majority judgments, with the dissenting judgments, my lords, compartment SC is a compartment, ST, another compartment, OBC, another compartment. Now, my lords, because of 51 judgments onwards, Balaji onwards, my lords, with utmost respect, even Ambedkar said in the debates, assembly debates, my lords, the poverty should be the foundation of the reservation. My lords are well aware, kindly note this point, my lord. The poverty should be the foundation of the reservation. Balaji onwards. Ashok Kumar Thakur, Indira Sahni, and repeatedly and consistently said that you should consider the poverty as the basis of the reservation. My lords are well aware, argued, I don't want to develop that again and again. Now what's happening, my lords? Instead of a caste-less society, since decades, we are trying for a caste-based society by promoting, by discussing, by debating, with utmost respect. From 51 onwards, how many judgments are there for reservations, SC, ST, OBC, how much percentage, some states are 100%, Tamil Nadu recently has struck down, etc. Here, my lords, in my note, there is a particular page I am going to give you, my lords. In India, first time, a community, Vaishya Shema Sabha, submitted an application to the Chief Minister of Kerala that we need that. Actually, they were getting this percentage of reservation this way or that way, but they said that we need 10% of reservation. Honorable Chief Minister said, this is first time I am seeing such a representation that people are bargaining for, we don't want the reservation. This is what happened in Kerala. So therefore, my lord, according to me, my lord, yes, according to me, my lord, the very foundation of the bill is the ground realities. The foundation of the act, objects and reasons. Objects and reasons, my lords, already gone through in the reply affidavit filed by the Government of India. Therefore, I don't want to see. What is the objects and reasons, my lord, with great respect? If I say, I am not in court number 1. If somebody, good scholar, researcher will say, Biju was not there. So, if we run after the judgments and judgments, we will get this judgment, we will get that judgment. But here, my lord, I recollect, if my lord Chief Justice may recollect, my lord Justice P.P. Singh and my lord Justice Hegde's observation, you tell us the facts. don't teach us the law, we will apply the law into the facts, and not vice versa. And second thing, my lord, I also recollect my lord Justice Sabarwal's speech in his retirement speech. He said,
Mr. Biju.
yes, my lord, because that's very important. Only one point is very important.
Point in issue.
Yes. Now, my lords, with these words, I am sorry.
Yes.
My lord, first one is short note about who is the respondent number one.
Yes.
And the caveat in Youth for Equality, Resolution 73. And I am appearing for them also. And the 103rd Amendment, the Constitutional Assembly debates preamble of the Constitution. Then, my lords, here I have a respectful submission, my lords. This is also argued as if, and as I read, where so much of things and arguments were there. I think a section of protected category also misunderstood or misguided, saying that somebody touched 15 for 15 by 16 or 16 by. It's a separate compartment at home. That's why, my lord. Now, then, therefore, according to me, Keshavananda Bharati case saying that what is the foundation, components, pillars of the basic structure. Well, as democratic, secular, justice, social, economic, and political equality of status, and upon page 2. So, therefore, how this bill became an act, whether rules of business of Lok Sabha and Rajya Sabha followed or not. So, my first submission, my lords, it is democratically passed. Out of 313 MPs, only 4 rejected.
Nobody has even seriously questioned the fact that it has been democratically passed. Correct?
Why I am saying, my lords, because there is an allegation arguing that fraud played on constitution.
That's all.
What is the fraud played is, I also, my lord, with
What he said is seriously argued. Correct? Yes.
Yes. And my lord, page 2, Kerala State Welfare Corporation for Forwarded Communities. Same.
Yes, please.
Different states are doing this. They are protecting their people. And my lords, Sindhu Commission, my lord, Indira Sani, my lord, kindly note this. Para 800 of Indira Sani says, for the Rishapullers, or any type of people who are suffering, that can be considered as caste or class, and accordingly we can give the reservation. Now here, my lord, Chief Justice asked a particular question, how you are perpetually poor. And others also argued that you take a lottery, then your vote will go. Even I don't have money for taking a lottery. So, my lords, in my in the first page, see, I highlighted one sentence. My lord, see the middle of that first paragraph.
Yes.
However, respondent hearing is not against the reservation of anyone. Because of my lord, after last day's argument, somebody asked, Biju, you are only for OBC, against OBC, etc. So we are not saying that. We are saying that once you are asking inclusion in EWS, you have to leave the casters. Which means if they want to sit on my chair both the time at the same time, that cannot be possible. You come out from the SC compartment, then you be in the EWS. None touched 15 for 15.5, 16 for 16.5. And my lord, next point is, so therefore, my lord, Sindhu Commission report.
Yes.
My lord, may kindly recollect 1980 Mandal Commission report, 1990 implemented. That is the basis as per para 800 of Indira Sani. 2010 Sindhu Commission. So 2019 implemented. So paragraph 800 of my kindly note this point. Paragraph 800 says that you have to have a data. So whether adequate representation is there or not, and data required is there or not. So two things established by Sindhu Commission report that this particular group, they are not a vote bank. Brahmin, I'm saying about Brahmin Rishabhular. I'm saying about the poor pujari priests of the temples. Early morning, 3 o'clock, they are going to the temple with a wet dress and coming back with some dashina. They are not vote bank. When Mandal Commission submitted its report due to its implementation, para 5 and 6 of Indira Sahni may kindly read what happened in the country. These non-vote banking people are not ready or not even having power to argue, bargain. That is why since decades you bracketed me as a Brahmin, as a forwarded community, then denied my basic rights. Now there is not a welfare legislation, but it's a historic legislation. It's a revolutionary legislation by touching the tears of that poor people. That is what, my lord, first page I am saying that I am not against your compartment. And at least what you are arguing, what is your fundamental right, where it is denied. If someone touched a 15,405 or 16,405, nothing happened. And something filed, my lords, repeatedly, that's not a post office. See the first writ petition, whether it is followed the guidelines of my lords, how to file a bill. So, 12th Act passed, 14th, 2 days writ petition filed without having anything. So, what happened, my lords? We must be very cautious because of a section of the people from the protected category misunderstood or misguided them that your rights have been taken away. For example, my lords, last day when I argued about, I said that Vaikin temple, somebody asked me, you are against SC, ST, OBC. What to say? So this is what happened with this repetition. So it has to be dealt with very strong hands of law, my lords, because it is affecting our country, and that law can be done only by my lords. See, what is their prayer? Did somebody touch their rights? No. But by touching the tears of the poor Brahmin, Rishabhular Brahmin, I am saying, Rishabhular Vaishyan, Rishabhular Kshatriyan, Rishabhular, our bus conductor, hotel employee, as land age is submitted. So just touched their tears. Now, what is your problem? Now you want to inclusion. Come, then you leave that compartment. This is what my lords, one area. Now, my lords, I said the objects and reasons, my lord. Then, my lords, you will see page 2 and 3, how this bill passed. And, my lords, page 4, my lords, my respective submission, page 4 top. According to my lords Keshavananda Bharati and the subsequent judgments, the foundation, the pillars of the basic structure is democratic, economic. Economics derives from the preamble of the Constitution itself. And this is completely followed, totally followed in passing this amendment. And this 15.6 or 16.6 is nothing to do with other articles. My lord, may kindly note this point. It is not at all inconsistent with any of the articles of the Constitution of India. So therefore, if it is, my lord, agreeing that if it is passed without any problem or without any illegality, considered by us, considered by other side, my lord, then my respective submission. Now you are touching, you are coming qua democratically passed bill or act. So who is trying to play fraud on Constitution? Not by us, not by this act. So you want?
I told you 15 minutes.
Yes, my lord. I am just complete. I am just complete. Because I am EWS.
No, you can take 5 more minutes.
Yes. Yeah. Then, my lords, Indira Sahni. Then economic criteria can also be considered. Indira Sahni, page 4 and 5, my lords. Then Ashok Kumar Thakur, my lords, paragraph I just indicated there, page 6 and 7, Nagarajan.
Yes, sir.
Then, my lords, page 7, 8.8, Roman 8, my lords, middle of the page, my lords.
Yes, please.
The submission of the petition exclusion is submission as we are already included. We argue for inclusion in the EWS. It is illegal, like SC cannot take benefit of ST, so and so, so and so. And my lords, then one important submission is page 7, my lords.
Hmm.
Now, kindly have the constitution for a second.
Yes, please.
My lords, I am saying what I am going to say, my lords. 31C is my fundamental right. May I read 31C, my lords, with great respect to my lords. Saving of laws, giving effect to certain directive principles, notwithstanding anything contained in Article 13. No law giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4 shall be deemed to be void on the ground that it is inconsistent with or takes away or abridges any of the rights conferred, etc. Now, my lord, may directly come to 39. So, 39, B and C especially, my lords,
Correct.
that the ownership and control of the material resources of the community are so distributed as best to subserve the common good, that the operation of the economic system does not result in the concentration of wealth and means for production of to the common detriment. So, my lords, now see how it is interpreted, this very relation of 31C and 39 is described in Keshavananda Bharat. That is what in pages 7 to 9, my lords. Now, my lords, I am answering to my lord Chief Justice's question that, my lord, again I am repeating to substantiate this table that none touched your rights, none taken away your rights. It's a special compartment with the available data, with the study report. As there was no adequate representation, the government appointed a commission in 2001 or 2, and that is submitted in 2010. That commission saying that after consulting each and every state government, saying that these particular people also has to have some consideration. So now, my lord Chief Justice asked, see how you can perpetually poor or the untouchability. If I am a SC, that will continue as SC. So therefore, tomorrow if I become a crowdworthy, even then I am SC. Very well. My lords, that's why my respectful submission, my lords. 51 onwards, in Indira Sani itself, as I indicated, my lords, that perpetual poverty is there. That is why state of Kerala, well, kindly page 2. That's why state of Kerala appointed a commission before this act. Page 2. The Kerala State Commission for Economically Backward Classes among Forward Community is a statutory commission constituted by the government of Kerala under the Kerala State Commission for Economically Backward Classes among Forward Communities Act so and so. Under Section 3 of the Act, the government of Kerala has to constitute the commission with a retired judge of the Honorable Supreme Court or High Court as chairperson with the 2 members belonging to forward community having special knowledge in matters relating to forward so and so. So, my lord, my respective submission, it is not first time. It is some other states also it's there. And therefore, what is my submission is this, my lords. The question is, my lord's question, my lord Chief Justice's question. It is not perpetually you are not poor. But I remember, my lord, I recollect my lord Justice Butt's question. You are poor. Your father is poor. Your grandfather is poor. So, my lord, this part 3 is not. I am not Indian citizen at all. Therefore, my lords, what they are having the rights, I want to send my children also to the school. My children also has to get some food, dress.
To be you,
So,
please confine to the point.
and my lords, my last submission is, my lords, that table.
Yes.
My lord, page 11, page 10, my lords, is very important. My lords, is this
Yes.
yeah, page 10, my lord. what is the result of this particular law is this. We are going to read an area which is a casteless society. This is the only community, according to me, or as per my limited knowledge, my lord, they went to the Chief Minister of Kerala and said, we don't want any caste-based reservation. We need that economic criteria reservation. My lord, this is the beauty of this particular act, my lord. We are reaching that. This is what the foundation of the debates assembly, my lord, makers of the constitution, my lord.
Yes, sir.
My lord, page 11 is Kerala State Welfare Corporation for Forwarded Communities. So other side is alleging that this is first time government of India did something. No, this was there. And my lord, page.
Your time is getting over.
My lord, 2 minutes. 2 minutes, my lord. I'm not. This is
So
I have to explain.
just now
Page,
next 3 minutes and
Yeah,
we'll
very
call upon the other.
page 12, my lord. My lord, Chief Justice asked me a question that what is the after effect of this amendment? My lord, may kindly see before 103rd amendment and before increase of seats. Well, it's extremely important according to me. My submission is this after this table that you are also benefiting in addition to what you are having. Because of why? It is increasing 10% seats and appointments, etc. So, what is you are getting before the amendment? My lord, A, row 2, A, SC, 15%, and total available pool quota A plus D. Now see, D is open category. Okay. SC plus open category is for SC 65%. Got it? Now ST B plus D, that is open quota plus ST 58%.
Yes.
Now my lords, C 27 OBC C plus D is 77.5%. They can claim only this. SC cannot come to the compartment of ST. So therefore, this is what before the amendment. Now my lords, my explanation is there. Now my lords may come. What will happen after the amendment? This is what my lord was asking to me. My lord, SC 15%, A plus D, total available quota. A plus D, D is open category 55.5%. B, 7.5% plus D, 48%.
Correct, sir. Less than 10. Less.
Now, my lord, how it will to be understand next is very important, my lord. Suppose total 100 seats are there. Sorry, 1000 seats are there. That is what important. My lord.
Yes, Mr. Biju.
Page 13. Top.
On this, it is true that what you have put in tabular chart is the scenario.
Yes, yes.
Nobody is disputing that. Correct? That's the effect of the amendment.
No, my lord, I'm sorry to say, my lord, with utmost respect to my lord's court, my lords repeatedly asked a particular question and they also argued one thing that we are losing something, or how it is affecting to SC, ST, OBC, whether something is going from their pocket. So here, my lords, last row 4, 1100, now from 1000, it became 1100, my lords.
Correct.
Then SC is getting 165 seats instead of 150, 10% increase. To them also. Then, my lords, ST also.
So therefore, the moment you increase the seats, naturally it gets cushioned. Correct. What your submission is that after the effect of the amendment and increase the seats are reserved, then there will be equality at the level where it was prior to the amendment and post the amendment.
Yes, and they are actually benefited in addition.
It may have happened in a particular fact situation, so therefore we'll note that. Any other submission, Mr. Biju?
My lords, now come to page 14.
Page 14.
My lords, page 15.
And I have already taken 10 minutes.
Yes, I finished, my lord.
Therefore, yes.
My lords, page 14 to 16 says that government also decided to increase the seats and appointments are there.
Yes.
And this is what my submission, my lords. Ultimately, my lords, again, I may submit that, my lords, this is not a case of affected their fundamental rights. Writ to jurisdiction 32, I request my lords, with utmost respect, my lords, I filed so many petitions, Devadas case, Trado case, so many. I was getting a call from the registry that this has not been followed, this guidelines has not been followed. I don't know how this 55 writ petition numbered, what is their prayer, etc.
Mr. Biju, argue on merits, correct?
No, my lord, not followed the guidelines, that's it, my lord. So therefore, my lord, ultimately my submission is that, my lords, the Sinhu Commission, adequate representation and these poor people. And accordingly, they have to get some kind of accommodation according to the constitution and fundamental rights. Their rights may be protected. With utmost respect, my lord, I am grateful, my lord.
Thank you. Thank you.
Be patient here.
Thanks.
Grateful.
Can I have only 5 minutes?
Yes,
There is some development, there's something which has come to my notice, that
Yes.
I am duty bound, my lord. But I undertake to place this in e-copy format as well as the bound format. It's only 1 page. Therefore, my lord, right now not in a bound format. Because as my lord, I have indicated that the government as a sovereign is responding to the my lord, wishes and aspirations of
My lord, I am going to another place.
Oh, yes.
aspirations of several, my lord. And this is what, my lord, we have tried. Para 3, my lord, 1 and 2, your lordships can ignore. It is submitted that contemporaneously with the constitutional amendment, a decision was taken in order to ensure that the seats available to the reserved category and the open category are not impacted in absolute numbers. The Department of Higher Education issued orders on 17 January 2019 to all central educational institutions to increase the intake in all branches of study to provide 10% reservation to economically weaker section while protecting the proportionate reservations for scheduled caste, scheduled tribe and other backward classes, and also not reducing the seat availability in the general category in absolute numbers in the year 2018-19. It is submitted that as per the calculations done in this regard, in order to provide 10% reservation for the economically weaker sections without adversely impacting the proportionate representation reservations to the SC, ST and OBC categories and not reducing the seat availability for the general category in absolute numbers as compared to admissions made in 2018-19, the total increase in intake has to be increased by approximately 25% over and above the intake in 18-19. It is submitted that a total of 2,14,766 additional seats were approved to be created in the central educational institutions and an expenditure of rupees 4,315 crore was approved to be incurred to improve the infrastructure in the higher educational institutions. This is proportionate, not saying.
Solicitor, correspondingly, I would like you, not right now, to give the data over a period, maybe.
Your lordships can.
Yes, give the data about the number of scholarships available to all people. Number of scholarships. There is a scholarships portal. What I have been able to get is a very limited. What is the kind of scholarship that you give for medical, engineering, and other professional courses, which are the subject of these central universities? The quantum of these per capita, scholarships, because we are looking at people, whether it's this or that doesn't matter. The poorest of the poor in all categories, ultimately, when they get in, what is the fee that they pay? What is the aid that the government gives? Because that is an important component also of affirmative action.
But since it has fallen from your lordships, it's my duty to, my lord, provide that detail. So, I very emphatically would respectfully submit that those figures and statistics would be relevant for the parliament to take a decision whether to provide for this or not.
No, you're
It
right.
cannot have any
No.
impact on the constitutionality.
No, you're right. We want to know. For instance, the National Scholarships Portal says that for a higher education, 82,000 scholarships are given throughout the country on economic basis. And there is a separate one for SC, ST. And well, I will not get a substantial amount is given, which is about 10 or 12,000 a year. Now, similarly for professional colleges or management colleges, what is the figure for even these EWS people to ultimately you're talking of the poorest of the poor or just marginally above that.
Poorest of the poor who are otherwise not getting any reservation benefit.
No,
Number
who are getting scholarships. So I just want to know. have
Yeah,
you-
my lord, it has fallen from your lordships. It's our duty. We shall place.
Yes.
But that since they are getting benefit, why give them reservation?
No,
Maybe a policy issue, not a constitutionality issue. That's all.
Mr. Solicitor, we are aware of what we are looking at.
No, your lordships are aware, more than aware, my lord. Even, my lord, even this affidavit, my lord, absent this affidavit, it would not mean that the constitutional amendment fails. And with this affidavit, it would not mean that constitutional amendment is constitutionally valid. This is for to satisfy your lordship's conscience. If, my lord, there is some my lord, doubt that this might have an impact on the general candidates who are otherwise meritorious. And if your lordships have any doubt that these are three silos, three separate zones, and if your lordships were to take a view that poorest of the poor, even in the first reserved category, should be shifted. You know, the economically weaker section, 10% should go there. It would result in two things. A, double reservation in the first category. And B, it would substantially amount to amending the constitution beyond the intent of the legislature.
Very well. Thank you, sir.
And a scholarship would also be merit-based as well as, my lord, need-based. I'm, my lord, subject to the verification.
Sure.
And last request, my lord, the learned AG wanted to place a note. My learned AG has not placed any note. My lord, which we will file it by tomorrow. My lord, he is in the process of preparation. I'm seeking my lord's leave. It would be your lordship's question and lord, possible answers on behalf of the government on constitution.
Benefit by reasonable classification because we can identify or distinguish the profession beneficiary belonging to economically weaker section of the family he belongs to. And this reasonable classification has been in existence for the benefit of people since long, and it flows from Article 14. So, on that aspect, this constitution. Now, regarding the matter of reaching the 50% barrier, my very humble submission is that the enabling provisions of the Constitution cannot contradict or override the mandate of our fundamental right. The legislations constituent 15.4 and 16.4 are class legislations, and they are forbidden by Article 14. They are not in keeping with Article 14. So, to my mind, they are untenable. So, considering them for 50% reservation is untenable. So, I believe that there is not peace. That's my submission, madam. On the issue of 10% fees being awarded and not being given to 16.4 categories, they have a place of reservation. Those candidates from the reserved category have two arenas. One is their arena, the reserved one, and one is the general category arena. They have two places. But the general category person has only one place. So he has been given provision in 10% of that. Now, when this OBC reservation came up, the right of the SC/ST people in the general category was also taken away in that sense. It was held constitutional then, it is, I believe, constitutional now. That's all, ma'am. Thank you.
Thank you. Mr. Ravi Kumar, who is going to follow you? Dr. Mohan Gopal, then
Mr. William, and I'll follow Ravi. And then Professor Mohan Gopal.
Because I fall in the middle, the petitioners could possibly respond to me as well, was my suggestion.
Okay, very good.
Whichever
We
way.
all
Chips go.
stand in one group.
I senior counsel who will address your order.
Very well.
No, in fact, after the court allotted limited number of hours, all the counsel appearing on this side, we have put our heads together and
Made some internal allocation.
yeah, some arrangement.
So we all will fall in one group. Gopal will be in another group.
Yeah,
Very good.
we'll proceed as per the consensus.
Sure, yes.
Great.
Great.
Sir, I request the court to kindly recollect the disaster of 2005 tsunami on this country. Lakhs of people perished and millions of people were uprooted. So the Indian Navy undertook an exercise to save the persons who are in trouble. So they went around the entire coastal area. In particular, we want to refer to this. Andaman and Nicobar Islands are devastated. And when the Indian Navy went to Andaman, they could find survivors, they rescued them, and they were able to do something. Very yeoman service was rendered by it. But when they went to Nicobar Islands, they did not find a single soul on those islands. So they declared that the Nicobaris have perished. It was a very dwindling population. So they declared. But again, they continued this search. And when, after 4 or 5 days, when they went to Nicobar Islands, to their pleasant surprise, they discovered not a single Nicobari was touched by tsunami. Then inquiries were made. Researchers came to find out how this miracle could happen. Then it so happened, the tribes of Nicobar, they live in such perfect harmony with nature. They could read the minds of the flora and fauna on Nicobar Islands. And when the monkeys started climbing up the hill, all of them climbed up and sat on a very high tree or took shelter somewhere on top of the mountain. Not a single Nicobar tribesman was killed. Why I am saying this is, they are the most primitive tribes. In India, the tribes and the scheduled tribes particularly, they are essentially classified as scheduled tribes because of their habitat. They live in such far-off places, not touched by civilization. And more importantly, almost all of them, they do not belong to the main race of Caucasians to which the mainland Indians belong. Now, all these races are eliminated. Nicobaris are eliminated, and all the tribes of Assam are eliminated because they are scheduled tribes. I may just give a short this thing. I've given. I've given a short note giving a sample survey of some of the tribes from their racial background. Kindly come to para 1.1 at page 3.
Yes.
Before I read that, may I request the court to kindly permit me to show who are scheduled castes and who are scheduled tribes. The definition clause may kindly be used. Article 366.
That which is declared under 341 and 343.
I respectfully agree. But who are declared? What is important for us is who are the people who are so declared? Kindly come to 341. I go down to this observation. Kindly come to Article 341 straight away.
For the purposes of this constitution in relation to each state.
Yes.
Yes. 341 says the president may, with respect to any state or union territory, and where it is a state, after consultation with the governor thereof, by public notification, specify the caste, kindly mark it, the caste, races, or tribes, or parts of or groups within castes, races, or tribes, which shall, for the purposes of the Constitution, deemed to be scheduled caste in relation to that state or union territory, as the case may be. So the entire list of scheduled castes and the entire list of scheduled tribes are either castes or tribes. Whatever confusion that prevailed among the OBCs, that I'll come to it later. But now consider this. In fact, crux of this matter is a question posed by Honorable Mr. Justice Bhatt on the earlier occasion. What if two words are deleted from 15 and 16, namely gender and caste? Would it not affect the basic structure? If I may say so with respect, that is the crux of the matter. So I have given the details of the races to which the scheduled tribes belong. They are not Caucasians. Mainland Indians are all Caucasians. And all of them, court may kindly take note of it, eloquent submissions are made on a casteless society. Sir, all these tribes are casteless. Why did they stay away from the mainland? Because they did not accept the caste system. That was one of the major reasons. They are very autonomous societies. They live on their own. They never subject themselves to be subordinates or superiors to anybody. And therefore, they remained outside the society. They went to the hills, they went to the forests, and that is where they are living. All of them, they belong to this race. And briefly, I may give the names of certain races. For example, the northeast tribes, northeast belong to Mongolian race. Tribes like Khasi, Garo, Tankya, Yelon, Minya, Anagamis, Cheslong, etc. And the central tribes, what is very familiar with these tribes, Gonds, Mundas, Santals, Marias, Beals, they belong to Astric race. And the South Indian tribes, like Betakurubas, Jainakurubas, Soligas, Irulas, Udiyas, Iligas, Kondas, Kodas, Kotas, they are from a Dravidian or Negroid or Astric racial features. So just keeping this in mind, kindly permit me to read the prohibition against discrimination under Article 15.1.
Yes, sir.
The state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. All these tribes have been eliminated from 15.6 and 16.6 only because of their race. No other factor. Are they not entitled to the benefit of anything that is done in the name of poor? Can they be eliminated? As Justice Bhatt was pleased to ask, can the words sex and caste be deleted from 15.1 for any program? Would it not offend the basic structure? Sir, I fall back upon the impact test. Please lift the veil of this provision. Put on the glasses to see who are the affected parties who are eliminated from 15.6 and 16.6. Are they not castes and tribes? Therefore, my very respectful submission is that question of Honorable Mr. Justice, but is the crux of the matter, and it is a clear indication that these two provisions have destroyed the equality code by allowing race and sex to be. Supposing a similar provision had been made saying that all positions in the Indian Navy or IAS are reserved for men, not for women, because women already have some benefits in 15.3. Would it be sustainable? Would it not offend the basic structure? If I may say so, in that permanent commission case, this Honorable Court has already declared as invalid any such elimination from being considered for permanent commission in the Indian Navy. So, if that is true so far as sex is concerned, in my very respectful submission, even a constitutional provision which eliminates these races, castes, and tribes also hits the basic structure, alters the identity of the constitution. So both impact test and identity test are answered in the affirmative if we lift the veil of this so-called economically weaker sections to find out who are eliminated. I'll not trouble the court. Enough is said about who are EWS. But who are eliminated, that is very crucial. So I therefore very respectfully submit that this answers the test, both impact test as well as the identity test. Because the equality code is turned upside down by enabling discrimination on the basis of race, on the basis of caste, on the basis of tribes. Article 341 and 342 are sufficient to demonstrate. 341 may not be a fundamental right, but it is a basic feature of the Constitution. And Article 46, I'll be giving the list. I'm glad Honorable Mr. Justice, but just now inquired, what are the scholarships that are given? I have, in my own way, compiled a list. I'll place it before you. In 5 minutes, I'll be placing it before you. So it is not an official list, but it comprehensively enlists all the welfare measures that are taken in the country and in some states also. And I request the court to kindly mark that in not a single case are the scheduled castes, scheduled tribes eliminated. There may be special provisions for them, but in the general welfare provisions, scheduled castes and scheduled tribes are not eliminated, not disqualified. They are eligible to apply, they are eligible to compete, and they are eligible to be given admission or given appointment. It is only under 15.6 and 16.6 that they will not be entitled to either apply or compete for the post or take any such benefit under 15.6 and 16.6.
Yes, sir.
Then one of the substantial arguments in defense of the EWS quota is that SC/STs backward classes are given for. Sorry, before I kindly permit me to show the backward classes also. They constitute a collection of castes and tribes that this Honorable Court has declared in a 13-judge decision in Indrasani. I'll give the paragraph. Paragraphs 779, 780, 781, and 782 may kindly be.
782.
780. In fact, the whole discussion from paragraph 756 to 779 relates to whether caste can be included, and para 781 court says you start with the castes. So castes are included, and what are now included are only castes as of now. There is no further classification which is permissible under this. So this may kindly be taken note of. Say that so not only scheduled castes and scheduled tribes, the entire human sea of eliminated persons for benefits under 15.6 and 16.6 are nothing but races, castes, and tribes, and they could not have been eliminated or discriminated under the provision. That is the bedrock of the equality code. Then kindly come to para 1.2. This submission I have made. I have only given a graphic description as to what happened in Champakam Dore Raja. Kindly come to para 1.2 at page 4. Sir, 14 posts were distributed under 3 categories to 3 different communities on the basis of religion. Hindus were given 12, Muslims were given 1, Anglo-Indians and Christians were given 1. Among the Hindus, Brahmins got 2, backward Hindus got 2, Harijans got 2, non-Brahmins got 6. So this was what was the position under the GO, which was popularly called as communal GO, which was struck down in 2 landmark decisions in Venkatramana for services and Champakam Dore Rajan for admissions to educational institutions. Now kindly come to the next statement, 1.2.2. Now what this amendment has done, it is a very, to put it simply, either applying the impact test, this is what has happened. 100 posts are divided into 5 categories. Scheduled castes, 15 posts. Scheduled tribes, 7.5 posts. Other backward classes, 27 posts. And economically weaker sections, 10 posts. Now kindly stop for a minute before proceeding to the other 40 seats or posts. Now what are these 60 posts going to be? They are going to be distributed strictly according with the communal GO, namely 15.6 and 16.6. 15.6 and 16.6 have converted the entire policy of reservation into what earlier was known as communal GO. 40% may be available, but that by itself will not, as this Honorable Court has repeatedly said, honor the doctrine of equal opportunities. So 60% of the posts to be divided, 50% was already divided in accordance with the Constitution as it stood prior to this amendment. And now the remaining 50% seats are subdivided into 10 and 40, while 10 go exclusively on the basis of. So in my very respectful submission, this is hit by the law declared by this Honorable Court in a 7-judge bench decision in Champakam and Venkatramana. So for this reason also, this needs to be struck down as ultra-vires Article 368. Then court may kindly recollect, till this point of time, neither the learned Attorney General nor the other counsel who have addressed, have provided as to what is the nexus between reservation and poverty. Why should reservation be given? Why not other measures?
Yes.
There appears to be some obsession that reservation is the only panacea for all ills, poverty, hunger, starvation of steaming millions. That was what was said. What has that got to do for IAS posts being reserved for them? Starving millions? IPS posts being reserved to them? IIM seats, IIT seats, institutes of higher learning. This is what is popularly known as reverse discrimination. Being obsessed with the concept of reservation. They want to extend reservation to everyone, whether or not that is needed. This has been held to be an unconstitutional exercise. In Ajit Singh 2, the constitution bench, at para 37, kindly, I'll not trouble the court with the text of the judgment. Kindly come to para 1.8. At page 10. Page 10. This Honorable Court has said, page 37, para 37, bottom of the page.
Yes, sir.
Kindly come to the bottom of the page. This is
Yes.
also a constitution bench judgment. Thus, this court has to ensure that in matters relating to affirmative action by the state, the rights under Articles 14 and 16 of the individuals to equality of opportunity are not affected. A reasonable balance has to be struck so that, kindly mark these words, affirmative action does not lead to reverse discrimination. In another case, another constitution bench judgment, of course, it is I think, dissenting opinion, but the words used may kindly be appreciated. It says, such decisions should not and does not imply that any undue accent on qualifications, the administration can cut back on the larger twist of equalitarianism or may hijack the founding and fighting faith of social justice into the enemy camp of intellectual domination by an elite. The court in extreme cases has to be sentinel on field. This is what has been said. So having said this, my very submission is the impugned amendment deserves to be struck down. Only clarifications which my learned friend, the Attorney General, made a very emphatic submission. Kindly, please. He said, scheduled castes, it is a homogeneous class. Scheduled tribes, it is a homogeneous class. Backward classes, it is again a homogeneous class. Now, with due respects to the learned Attorney General, now this issue is already settled. So far as OBCs are concerned, Indrasani has permitted categorization. Now, on almost all these states, there is categorization. Of course, central OBC list categorization has not yet happened. But in other states, most of the states, in Karnataka, for example, we have 5 categories among the backward classes. So, categorization. So, it is not a homogeneous class. That's what I would like to emphasize. And so far as the scheduled castes are concerned, Caste are concerned, court may kindly recollect, as early as in 1965, a committee was appointed by Government of India to go into the working conditions and the problems of scheduled caste and scheduled. They recognized the fact that this is not a homogeneous group and therefore deserves to be differentially treated. That has not happened. Be that as it may, in the latest case of Devendra Singh, 2022 SCC, page 1, 2020.
The issue has been referred to
Yes.
7 judges.
So therefore, should the issue of SC/STs being homogeneous and therefore they cannot be subdivided into poorer sections and not poorer sections, that issue, with due respects, it is a matter which is pending before a larger bench of 7 judges. And therefore, that argument may not be available. Para 27 of Devendra Singh has declared that creamy layer may be eliminated from scheduled caste. And about subclassification, the entire case law is reviewed. In particular, Indrasani is followed, Jarnail Singh is referred to, and then the court says that subclassification is permissible. Paragraphs 35, 42, 44 to 48, 51 and 58. In express words, this on court, a constitutional bench has declared that it is not a homogeneous class.
That's a referral order.
It is a referral order. I respectfully
Therefore,
agree.
it's not
But
something which is a
opinion
final
has been
determination or
Opinion has been expressed
Opinion.
as to why Chinnaya, which declared it as
Correct.
homogeneous, a bench of coordinate strength has expressed that judgment is incorrect. That is what I want to say. And I'll not read the judgment because my learned friends are eagerly waiting for my conclusion. One last submission before I conclude. One of the justifications given is that EWS classification has already been upheld under the right to education. I request the court to kindly note, kindly permit me to show from Article 21A, right to education. Under Article 13, any law that infringes fundamental rights will be hit by Article 13 and it will be invalid. But kindly give a close perusal of right to education 21A. The state shall provide free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may by law determine. Sir, this is a very incongruous provision, if I may say so with respect, which would never fit into the doctrine of fundamental rights. Whatever law the state makes is going to be a fundamental right under this, that is declared to be a fundamental.
the extent is limited by that.
Yes. So EWS category is one such thing. But more importantly, kindly take note of the fact that EWS is an inclusive definition. It includes backward classes, it includes scheduled castes and scheduled tribes. Article 45 as it stood before this amendment, kindly appreciate the fact. In the entire constitution, there was only one provision. No, it is no longer there on the 45 has been amended. Sir, this provision required within 10 years.
Just to take it further, the provision in RTE, that Right to Education Act, it defines
Yes, it defines EWS.
inclusive. That is inclusive.
Inclusive.
That is noticed in Pramati.
Yeah, Prabhati, yes, I respectfully agree. It has been upheld in Prabhati. That's because that it is an inclusive definition, number one. Because SC/STs can never be included from the concept of weaker sections for any purpose whatsoever. And more so, because 21A in its very nature, it gives such a free hand to the state to enact any law which will be considered as a fundamental. And more importantly, this was to achieve the object of Article 45 as it stood prior to amendment, which provided free and compulsory education to all within a period of 10 years. This was the only time-bound program under the Constitution that has now been deleted. So, therefore, my very respectful submission is, Ramati cannot be relied on as an authority to say EWS is. And now I have received the compilations. May I just pass on?
Yes, please.
Sir, one of the questions that was debated was whether Muslims are included in the backward classes. I have given the list of all Muslim communities that are included in the backward classes. That may be found at page 42. All the Muslim sections that are included is at page 42. And the Christians who are included now under 16.4, that list is at page 46. I've also given a tabular statement regarding the number of castes that are subsequently added after the original notification of 10/9/1993 to the list of backward classes. Kindly come back to page 38.
Yes.
Yeah, a tabular statement at page 40 would suffice to say that as on 31/3/2018, 2,513 castes are found in the list of OBCs. Of them, 775 castes are newly added subsequent to the judgment of Indra Sahib. Then to answer the query of Justice Bhatt, I have placed all the welfare measures that are in operation under Government of India schemes. A large number of them relate to, kindly mark it, education, higher education, skill development. So kindly appreciate the fact in not a single scheme the scheduled castes and scheduled tribes are involved. So welfare concept necessarily includes.
In fact, they are given special scholarships also.
They are given greater incentives. They are given
One could be specially for the community based and one could be based on
general,
EWS.
all general schemes. I have given the list of general
Yes,
schemes.
emphasis is wherever EWS, they have always been included.
Yes, I
That's all.
respectfully agree. So with these submissions, I
Sure.
thank the court for this patient hearing. Sir, this is for the first time case involving 100% of the population comes up. When reservations in favor of scheduled castes came, it was only scheduled castes who were affected. Scheduled tribes came, only 7.5% were affected. Or the general category came, only about 15% were the affected parties and they came before. For the first time, this court is called upon to address an issue which will affect every Indian in the country. I therefore while thanking the court for expedited hearing, call upon this court to rise to be judicial statesman to strike down this amendment as violating this. Great. Thank you.
Lords, I want to briefly respond to the AG and SG submissions with reference to the 50%. That's limited the arguments are going to be. I won't take long. Just if I can quickly take your lordships to 2 or 3 aspects of it. The first, my lords, is this, that I think I was perhaps misunderstood, both by the respondents and I'm afraid the bench, if I was understood to say that Muslims and Christians are not included in the OBCs at all. What I was saying was simply this, that the argument that had been taken thus far was that as a consequence of this amendment, what happens is that you are providing this reservation only for forward castes. I was saying no, in that EWS, you will find, apart from Hindus, you will find Muslims and Christians. Significantly, we have Muslims and Christians in the OBCs. That compilation I've given your lordship will show your lordships that. But we don't have them in the SCs and STs. In the SCs, we don't. And that's why both the 2 commissions which I mentioned earlier, I have in that small compilation I've just handed up. Just give this. I've put the terms of reference of the Sachar committee as well as the terms of reference presentations, and there is a summary. I must say that these committee reports have not been accepted formally by the government. In fact, on Thursday, Mr. Tahir Mahmood, writing in the Hindustan Times, said he is the only living surviving member of the Ranganath Mishra committee, and he wanted to set right the record that appeared to be there, that the Ranganath Mishra committee's report had been rejected by the government. He said it's not been rejected, but there are recommendations of ours with reference to all minorities. The earlier Sachar committee report was specifically dealing with Muslims. If your lordship will just come in this compilation for a minute to page number 7, there's a summary there. There's a summary by PRS legislative. And just quickly, this gives the summary of the entire Sachar committee report, which shows light of the Muslim minorities. Specifically at page 8, if your lordships can come, to table 6. Salaried workers employed in government, public and large private sectors. All Hindus, your lordships will find, which is broken up into SC/ST, OBC, upper caste. The SC/STs is 30.4 and public private is 12.8. Muslims is 23.7 and 6.5. These are the numbers here, and if your lordship comes to page 9, right side column, second last paragraph, poverty, consumption and standards of living.
Which table?
Page 9, right side column, the second last para,
Yes.
is that heading which says poverty, consumption and standards of living. Muslims face fairly high levels of poverty. Their conditions on the whole are only slightly better than those of SC/STs, though slightly worse in urban areas. According to NSSO data, overall 22.7% of India's population was poor in 2004-05, 251 million people, with SC/STs together as the worst off at 35%, followed by Muslims at 31%. So these worse off Muslims, the 31%, have to be catered to. And this is possibly one of those measures which can cater to them. Overleaf, page 10. Muslim, OBC and affirmative action. These 2 paras, if your lordship will permit me. The report compares the status of Muslims who are not listed as OBCs and thus do not qualify for reservations with Muslim OBCs. This is what I was talking about. At least 82 different social groups among Muslims were declared OBCs by the Bandal Commission. According to the last round of the NSSO survey, 40.7% of Muslims are Muslim OBCs, which is 15.7% of the total OBC population of the country.
No,
According to the report,
Muslims are all.
So 47% of Muslims
are OBC,
Muslims
are
OBC as
in the OBC. But
declared.
yes, as declared.
They are the 15
But next para, according to the report, the abysmally low representation of Muslim OBCs suggests that the benefits of entitlements meant for backward class are yet to reach them. The conditions of the general Muslim category, this is the remaining 60%. General Muslim category are lower than the Hindu OBCs who have the benefit of reservation. Please note that. However, the conditions of Muslim OBCs are worse than those of the general Muslim category. The three groups of Muslims in India, Ashrafs, Ajlafs and Arzals, in order of caste hierarchy, require different types of affirmative action. So, this was only just briefly to demonstrate that this argument that this EWS 10% is only for forward caste is completely misplaced. There are several other groups who are also represented. Mr. Ravi Verma Kumar has just shown your lordships those lists. The first page of this compilation I've handed up is to show your lordships how we have expanded these groups. I don't think he was right in saying that, look, this is a discrimination on a race basis that is happening, or a gender basis, or a tribe basis, which are the three phrases he used, saying Article 14 is violated, because your lordships know that, for example, the Meenas in Rajasthan are an ST group. Now, this is not based on a racial characteristic. They are not considered Mongoloid or anything else. It is based on being added. If your lordship sees these three boxes at the very top, it shows from 1950 till now, we have increased these groups from 247 to 736 among the STs, not on a tribal basis or a racial basis. This is the basis of backwardness, and they are tribal groups, not on a racial basis. I re-emphasize, because that was the argument where this started from that example in Nicobar. 318 SC groups has come to 1,283.
One has reservations about these.
Yes.
Because the matrix which is employed for putting a community in an SC or in a, because there is a separate lists.
Yes.
They are entirely different. There are
Yes.
anthropological, ethnographic studies.
Yes.
I don't think we are equipped to get into.
Absolutely. That's exactly what my submission.
Nor are we in a position to say that increase or decrease is.
I'm not saying that. I'm completely.
So I don't think this.
I'm completely accepting what your lordships are saying. Therefore, race can't be the basis on which
your submission that 10% is not meant for forwards alone.
Yes.
Is certainly.
That's the submission.
That's the point.
And now, if your lordship, no, I was saying that therefore race can't be the basis for us to proceed in examining this.
The point is taken.
Yes.
The point which is being emphasized, argued by Professor Verma also, Ravi Kumar Verma sir today.
Yes.
And earlier council also. This is that exclusion.
Yes.
SC, ST and OBC.
Yes.
That the persons
correct.
16.4 and 5.
Yes.
15.4 and 5. Out of this 10%, that is the problem.
Yes, that is the point.
See,
no, that has
to illustrate, just to illustrate what.
Yes.
Whatever communities are OBC, and
yes,
you pointedly mentioned Muslims.
Yes.
The interpretation which more or less both of you suggest,
yes,
both sides
yes,
suggest, is the other than means that 14 categories. That such of them who are in these 40% of these who are in the OBC,
yes,
they are excluded from consideration.
Yes,
that is the one which is
yes. That seems to be what they have. Now, if your lordship will pick up this chart, this is to compare the position prior to this amendment and post the amendment, because your lordships may note that the AG very specifically, and the SGs have adopted this, said that this additional 10% falls in a separate compartment. Therefore, your lordship will recall when I argued, there was a soft option and the hard option in the addition to the existing reservations. Your lordship were kind enough to suggest that, look, maybe the soft option can be adopted. The position the government has been taken is to put an obstacle there and say no. The SC, ST, OBCs are essentially untouched. It's a separate compartment where you have a 50% ceiling limit. Over and above, separate from that, separate but equal, you have this 10% which is for a EWS. In my view, if compartmentalization of this nature is permitted, we are effectively going to go back to a Champakam kind of situation where you're going to compartmentalize each group and say that we have compartmentalized. I don't believe compartmentalization is at all a phrase that you can use when you're dealing with enabling provisions like this. Because the minute you add this compartment, it takes us about 50%. And then tomorrow they come with an additional compartment. They will call it a compartment, have a vertical reservation for another group. It may be some other disadvantaged group. And this compartment argument will be used to take it all the way to 90%. Take a look at the effect today of this chart. These are not compartment moves. Picture 1 is what it stood now. I've taken for an illustration 100 seats or 100 posts. This entire chart on the left side is 100 seats, split into 49.5, which are the yellow, and 50.5, which are the cherry. I've put the horizontal reservation, that's the women, that's W. EX is ex-servicemen, and PWD is persons with disabilities.
Sorry, Mr. Shankar.
Yes.
To interrupt you, sorry.
Yes.
Even this may not be correctly
A
depicting
depiction
the
of it.
position which is existing. Compartmentalization as such you can't deny. So far as SC, ST and OBC, in that 49.5% also, there is compartments, sir. There are compartments.
No, I'm not
The SC is not
cannot get a reservation to SC.
and so on, right?
Yes.
So those compartments are indeed there. EWS also as conceived.
Yes.
This is a compartment.
Yes.
Obviously, we have to take it to be a compartment. What
Yes.
we are saying is, sir, that the focus of this entire debate ultimately would be whether it hits, whether it affects, whether it alters the basic structure or not.
Precisely.
So let us concentrate on that. aspect, sir. All these statistics may not ultimately
Which is-
see on the matter. That is what we feel.
Which is precisely what I'm doing. Explain that the argument today in an enabling provision under the Constitution is only between reserved and unreserved. That's all. Creating an artificial classification in among them, saying that compartment for OBC, compartment for SC, compartment for ST, and compartment for EWS, and arguing, and this was their argument, that 3 of these compartments can go up to 50%. The 4th compartment is a separate compartment, is no argument at all. I am saying, as far as the reserved, vertically reserved are concerned,
You're
the
presenting,
ceiling,
what you're presenting as horizontal
yes,
actually may not be a feasible option. It could be feasible up to the OBC point. For OBCs, Indira Sani says you can categorize, and there are categorizations, as Mr. Ravi Verma Kumar said,
yes,
in different states, but we don't know really.
yes,
Which is, if you are going to strictly apply the income criteria and ignoring the 50%,
yes,
just keep aside the 50%.
yes.
The one way is the horizontal way of presenting. If you were to further it, then you present it vertically. In
This
that
is only a vertical presentation. I don't know if I was permitted to explain. This is purely a vertical. It's only just so that I can show you the horizontal also. I put the letters in. This is only vertical. Yellow is reserved. Green is unreserved. Ignore the horizontal. Ignore all the letters in the middle. That's only to illustrate for your lordships that there is a horizontal existence in this. Otherwise, yellow
this
is-
you're right.
Yes.
If you don't see this as horizontal, it
Yes.
is vertical, and
it's only vertical. I'm trying to
everyone
explain.
is seeing that.
Yes, I don't want to be faulted saying you've left out the horizontal, so I put those letters in to illustrate that there is.
Come back in.
Yeah. Yes. But I was just pointing out that your lordship may ignore the W's, the EXs, and the PWDs. That's only to illustrate that those are the horizontal classifications illustrated. That's all. But it's a vertical classification that is illustrated here. The yellow are the reserved, the green are the unreserved. Right now, 49.5 and 50.5 as it stood before the amendment. After the amendment, your lordship sees that the yellow has expanded now. Following what fell from the government, they say that the 10% is an additional compartment over and above. So it becomes 59.5 effectively. I'm just taking these numbers, can't be used by me as permanent. I'm just taking what they said. They have said that we are not touching the OBC, CST compartments and those numbers. And now their affidavit shows that even on the ground, as far as the postal seats are concerned, they are keeping it limited so that those numbers don't get disturbed. On the right side, if your lordship sees the consequence now, in the green, that number has shrunk to 40.5%. In that pool of 40.5, please note who all are included. That key at the bottom right hand. Hindus who are non-OBC SC/STs are included there. Muslims, Christians who are non-OBCs are included there. So just to illustrate that this is not a caste issue at all. other religions, whoever they may be included there. Meritorious OBC SC/STs, that is those who are in the yellow but following the Sabharwal principle, who have merit, they will be calculated here. They won't be calculated there. So you are trotting on their toes itself by bringing the 10% in there. I hope I'm making myself clear.
You are right, yes.
And meritorious EWS. Now that you brought this EWS in, if there is an EWS person who is making it on his or her own merit, that person will also be here in the green. Therefore, all of these people are in the green and they have been shrunk. Now the argument, and I think the Solicitor General put it across quite strongly and I think accurately about the basic structure violation needing to be something that is quite extreme, that is shocking, unconscionable. It can't be just a mere violation of equality. And the question therefore arises, is this 50% violation something so shocking and unconscionable?
Then you're starting from your previous argument.
I am-
50% is a hard.
I am adopting the same. I am saying it is shocking and unconscionable. I am explaining why it is shocking and unconscionable. Not only have your lordships in two judgments expressly in the context of a constitutional amendment said so. Justice Maheshwari pointed out para 120 of Nagaraj, to which there is no answer still. Nagaraj says that 50% is a controlling limit. In Krishnamurti, again with 243D and 243T, 50% was brought in, again as a ceiling limit. Those ceiling limits were brought in the context of constitutional amendments. So your lordships already in 2 benches of 5 have said that is the standard. Your lordships have said that. In addition, the Attorney General's written submission that your lordships will take, I'll just read out one sentence from page 13, where he said, this is para 23. Para 23, page 13, if your lordship don't have it ready at hand, I'll read it out.
Yes.
Based on these very arguments, is referring to Chinnaya, one would be entitled to contend that the words other than the classes mentioned in clause 4 and 5 in Article 15(6) and the words,
Which page you said?
it's page 12, bottom, going into page 13, para 23, I'm sorry. Based on these very arguments, one would be entitled to contend that the words other than the classes mentioned in 4 and 5 and 15(6) and other than the classes mentioned in clause 4 and 16(6) cannot possibly be invoked to seek the same reservation as the one extended to the EWS forming part of the general category. In case a similar reservation was to be extended for the EWS and the backward classes, the reservation would then automatically exceed the 50% limit, and this would be counterproductive since the argument of the repetition is that exceeding 50% would damage the basic structure of the Constitution. So even this argument acknowledges the fact of the basic structure would happen if it was 50%. Therefore, it was therefore that the words other than the class mentioned in should be enacted while conferring the benefit of reservation in the EWS and general category. So even the government admits that they accept this, and their way of countering it is to create this additional 10% compartment, saying it's a separate compartment. So even they acknowledge the strength of 50% being a ceiling limit. Plus,
If we followed their argument correctly, sir, this was a specific argument. 50% ceiling is not
Right.
sacrosanct.
That's
What is
I agree. I'm just going by what they stated here. I'm saying that
what the argument we have made. That has been their emphasis that 50% is not sacrosanct.
that's what they've said. And the reason for saying that we cannot have it as a basic feature is, as the solicitor said, that you can't have something which is flexible as a basic feature. Now, I would show your lordship the NJAC judgment. You don't have to go to the judgment. Briefly, what was it? 124A was brought into the Constitution. It brought in a commission which had 6 members. Those 6 members included 2 members of civil society nominated by the Chief Justice, the Prime Minister, and the leader of the opposition or the single largest party. In those 6, 3 were judges, 3 were non-judges. Your lordship said that upset the balance. This upset independence of judiciary and separation of powers. 4 out of 5 judges said that. Their argument is what Justice Chalameshwar in dissent said in NJAC. Their argument was that this is a flexible rule. 50% is a flexible rule. If it's a flexible rule, it can't become part of the basic feature. What else was applied in NJSC than that? A question of numbers, where your lordships feel that since the judiciary doesn't have 4 out of 7, but only 3 out of 6, it violates the basic structure. It was treated to be unconscionable. It was treated to be something which was shocking, using the words of Justice Krishna, unscrupulous. It was so extreme that it violated the basic feature. So, I would argue that it isn't necessary for basic features to be flexible versus inflexible. It can be both. It depends on a case-wise scenario. In this case, I believe 50%, exactly as Justice Bhatt has praised it in Jayashree Lakshman Rao Patil, 50% with the exceptional circumstance. That phrase is a basic feature of this constitution, and what they are doing by virtue of this additional compartment over the 50% is a breach. So I would once again emphasize that those words, in addition to the existing reservation, those words need to be culled from the constitution, need to be severed. Because if this is permitted, the floodgates open. Because the next constitutional amendment will come with another compartment. At which point your lordships will be forced to entertain an argument saying 60%, then maybe 70% at each stage. The idea of 50% having been rooted now for 70 years and recognized in 16(4)(b), 2 constitutional benches dealing with constitutional amendments, makes it clear that the balance has to be maintained. That's all we're saying. We're just saying maintain the balance. Within that 50%, play with the percentages however else you want. That's a policy decision. Because I won't take any more time. I've already been told that I'm arguing against my own side in a way. So I'll just stop with that. In that small compilation I've given your lordship, the last 2 are Mr. Palkiwala's articles. Your lordship may see it.
We the people, or we the nation.
Yes, we the nation. I'm most grateful. Most grateful.
Thank you. Who comes next?
Yes, please. Lord, I have prepared a compilation, Lord, which contains, Lord, the written submission which I have already filed.
What it means is that every succeeding council is again, giving us compilation after compilation.
No, Lord, that is,
That makes our task
So-
difficult. But not that I am opposing or coming in there.
I am not giving, Lord, 60 pages or 100 pages.
How
with
do we
the
respond?
Solicitor General gave us.
We respond.
He took us by surprise. Lord, to cut short our, Lord, submissions. What I have done is, Lord, whatever I have given earlier, I have made it as a compilation. It's not something new. The Lordship sees, Lord, annexure. 11-page, Lord, I'll tell you, Lordship. Lord, my written submission which was given earlier is annexure P.
Before you begin, the art of responding doesn't mean that you write down beforehand and down. When Golaknath was argued here, I am told,
Yes.
it was argued only for 3 weeks. And then the propositions were given by the council who opened, Mr. Arve's Mani. And when he reached point number 10, till then, that is in 1966, there were no written submission. When he reached point number 10, Justice J.C. Shah threw down the pen and said, now I am not going to write. I am not your steno. Please put it in writing. That's how it began. And now we have this.
And my lord, on a lighter
font.
look at the font size, yes.
The Lordship kindly.
Oh, my lord, that there are less number of.
That had been
Lord,
argued
so far as,
every learned council
yes.
that this insurance policy fonts.
But if I follow,
Sir, you
if I follow Mr. Tushar Mehta, then I have to give him, Lord, at least 10 pages. I read
14, we said 3 pages and that,
Yes.
that was
Yes.
the outline. Now this is 14.
No, my lord, this is actually, my lord, it contains the earlier one which you have already given. Then, my lord, list of citation at page number, my lord, 7, which you have already given. And rejoinder, my lord, if your lordship sees only, my lord, 6 pages.
We will perhaps, I think, we'll have to take a call, whether we go by your original submissions.
No, my lord, this is only a reply. My lord, we are only, my lord, we are giving a rejoinder, my lord, to whatever they have made submission, because lot of submissions have been made. My lord, this is not a case as my lord Ravi Verma said.
We'll again call upon all the councils
Yes,
to put in the rejoinder submissions in not exceeding 3 pages.
yes, my lord. Lord, if your lordship sees, greatly obliged.
Yes.
Lord, we wanted
14.
You must also do some bit of homework rather
Yes.
than put it pure.
Lord, this,
I
yes.
have not tendered at that time. I have only a 3-page submission that
Whatever, yes.
I have done that elaborated part of extracting the paragraphs from judgment and the rejoinder is
Ms.
pages
Arora,
at the end.
whatever you said
Together.
that day, the 3 pages exceeded that. So we have noted whatever you said, the paragraphs, everything is there.
Yes.
Your para
Because we've
102,
explained, if my
para
lords
3,
find it
so
convenient,
that is-
my lords may use it. If my lords feel that it's not
Lord.
necessary, my lords may not look at it. But for the purpose of convenience, it's tabulated, it's with footnotes, with paragraph.
Shall I tell you one thing, Mr. Arora, with due respect? Yesterday I was looking at one of the judgments of this court, Pramati. Pramati is a 48 paragraph judgment. 283 pages just have gone into these written submissions.
Yes, that's correct, my lords, absolutely. My lords, we had judgments, if my lords will look at the earlier years, only in 6 pages or 8 pages and laid down the full
Look at Champagam Dorai Rajan, just
And
about
then
4 pages.
My lords, Indira Sani was like a volume, and then others
The
were a
youngest
volume. So, my lords, we have also kind of evolved accordingly.
Goes in argument,
40%.
40%.
In fact,
We have not
but as Mr. Ravi Verma said, Lord, this is concerning Lord the whole lot of population.
Very well, let's not waste time,
Yes.
sir. Go ahead.
Lord should kindly see, Lord, this amendment 103, Lord, constitutional amendment, Lord, puts us a status quo ante. What, Lord, the reservation, Lord, so far as, Lord, the oppressed and depressed class, Lord, recognizing, Lord, that they were kept away from the mainstream to offset, Lord, the social discrimination and, Lord, to see that the inequality is being taken away. Now, Lord, this 103rd constitutional amendment, Lord, puts really, my Lord, us back, my Lord, to the pre-constitutional stage. My Lord, in fact, the Indira Savani case itself clearly says, my Lord, any reservation on economic criteria, my Lord, will lead to a virtual deletion of Article 15.4 and 16.4. That was a caution struck, my Lord, not, my Lord, simply, my Lord, there was any observation. There was a EWS, my Lord, reservation given on the basis of an office memorandum. But what was interpreted, Lord, is Article 14, 15 and 16. Lord, that is what I wanted to remind, Lord, this, that, Lord, only to uplift, Lord, the poor, Lord, this reservation is for. Lord, there is no dispute. But the question is, Lord, can they be uplifted, Lord, through this reservation? Lord, the answer, Lord, is an emphatic no, because reservation, Lord, is not a poverty alleviation program. Lord, that has been already decided. And, Lord, indigence also is not a basis for reservation. Lord, one important document, Lord, which the Solicitor General and Learned Attorney General relied upon, Lord, the Sino Commission. Lord, in fact, Sino Commission, Lord, did not support them at all. Lord, if your Lordship, Lord, I have gone through the Sino Commission thoroughly. Not only Sino Commission, Lord, and also this NSSO report. If your Lordship sees, Lord, the Sino Commission itself did not recommend for any reservation. The Sino Commission said that if you want to give reservation on the basis of Lord, economic criteria, then abolish all type of reservation and give reservation on the basis of economic criteria for all of them, irrespective of caste, creed, and religion. Lord, that is the observation, Lord, that I have even mentioned, Lord, page number 695 and 696 of the convenience compilation. Much is said about the Sino Commission, Lord. In fact, Sino Commission, Lord, has not supported their arguments at all. Lord, paragraph number 8.6 to 8.9, what they have said is, Lord, they have said target welfare schemes to bring in for EWS in the FC category. That is what, Lord, the Sino Commission has said. Lord, in fact, Sino Commission, Lord, has gone to the extent of even saying that there is no data available, Lord, so far as the economic backward class is concerned. They have said it in categorical terms. Lord, I have said that, Lord, in paragraph paragraph E, Lord, 1E, it's at page number 712. Lord, in fact, the Sino Commission itself has recommended to conduct socio-economic surveys of economic backward classes within the forward caste. Lord, that is at page number 711. That, Lord, page 711. Sino Commission has gone to the extent of saying that, Lord, there is no empirical data so far as the economic backward class are concerned. Therefore, my lord, in absence of my lord empirical data, my lord, reliance of Sino Commission, my lord, at page number 24, my lord, on the basis of one NSSO survey, and my lord, which has been relied by the Attorney General, my lord, to say that 31.2% of them are, my lord, poor from the forward class is concerned. My lord, my humble submission, my lord, that data itself is wrong. Why, my lord, I'm saying that data itself is wrong is, I have gone into that NSSO data, my lord. In fact, I've given even the, my lord, where it can be downloaded. That NSSO data is nothing but, my lord, it's a household consumer expenditure, employment and unemployment data. The survey was conducted, my lord, on 1,24,680 households in 7,999 villages. And, my lord, no, my lord, survey was conducted on social status. My lord, in fact, if you also see, my lord, H, I've clearly said H. NSO data is for different purposes. Blood reliance for identification of backward class blood. Nowhere this NSSO speaks about blood economically backward classes or economically weaker sections. Blood, in fact, they themselves admits blood that the social group which they meant is blood. They used to blood do a random sampling, walk into some house, ask one person head of the family, and then collect the data. That is what they have said. Now, do they not reflect the entire family? Your lordship knows in an entire family, economic condition varies from each and every one. My brother may be rich, Lord, I may be poor, and my younger brother, my lord, may be in a different category. But that is the data, my lord, which they have collected, and they themselves have said, my lord, that these are all the data which we have collected. Therefore, my lord, my humble submission would be, so far as reliance of the Sino Commission, my lord, and the data, my lord, which it relies upon NSSO, my lord, is not going to help them in any way, my lord, for bringing in this reservation. The Lord knows for any sort of reservation, this court has been, my lord, very categorical that you should need an empirical data. When Sino Commission itself admits that we don't have any empirical data insofar as the economic backward class is concerned, how will you justify your economic weaker section data is concerned? Because your affidavit, your counter affidavit, your arguments, everything, my lord, relies upon the Sino Commission. Sino Commission, in fact, relies upon NSSO, and NSSO makes it very clear this is not one which relates to a social status or for a not a EWS, not a C or for a not a backward classes. That's what it's very clear. Then, my lord, my humble another submission is about the compartment theory. Lord, one of the arguments, Lord, of learned Advocate General is that Attorney General is that this is a watertight compartment. The reservation is given insofar as the one compartment, they can't seek reservation from the other compartment, my lord. And the 10% they say, my lord, is an exclusive reservation so far as the lord, the forward class is concerned, that is EWS. My lord, my humble submission would be, my lord, this compartment theory, my lord, enunciated by not the learned Attorney General, my lord, cannot be correct because your lordship knows, my lord, the backward classes or, my lord, the scheduled class and scheduled tribe, they can even compete, my lord, in the open category. In fact, my lord, I have given the citations also, my lord, I will not trouble your lordship by reading that. Then, my lord, your lordship knows, my lord, that your lordship can see, my lord, the two judgments, Samatha Andolan Samiti, as well as, my lord, this Tirupari Charan, where, my lord, they say that Lord, competing in the open category, they can't be even counted, Lord, in the reserved category. That is what it says. Therefore, this open category is meant for all. It cannot be counted, Lord, towards their quota. Now, Lord, one of the argument is that extraordinary situation, Lord, arises. Lord, what is extraordinary situation? Now, Lord, if a lordship sees Sino committee, Lord, they never considered, Lord, or dealt with an issue of an extraordinary situation. Or, Lord, the bill has dealt with an extraordinary situation. In fact, Lord, due to the economic growth, Lord, the poverty has reduced. Lord, in fact, after the judgment of Indira Savani, Lord, Lord, the judgment in J.C. Lakshman Rao Patel, Lord, they have made it very clear, Lord, what is that extraordinary circumstances? They mean, Lord, cut off from the mainstream. Lord, here, they are already in mainstream. Lord, they are already in mainstream. That is what the finding of Indira Savani's case. And where is the question of, Lord, the extraordinary situation being raised? Therefore, Lord, my humble submission would be, Lord, that argument, Lord, of extraordinary situation as arisen is only, Lord, on the air. It cannot be seen in paper, no data, nothing. Sino Commission doesn't say so, bill doesn't say so, Lord, and therefore, Lord, this argument, Lord, cannot be accepted. Lord, this Sino Commission was very mysterious, Lord. I should place this because this is the order of this court, Lord. I'm going to take your Lordship, Lord, how the Sino Commission surfaced. Yes.
You have limited time.
Yes.
Why?
Lord, I have said, yes, Lord, I have said why it was kept, Lord, as a secret document. I have given the page number also, Lord. This court has recorded that, Lord, in another case. Lord, I will not trouble your Lordship, Lord, by saying that. Lord, in fact, Lord, the arguments, Lord, that it is a reasonable classification, Lord, all that, Lord, they are not able to meet out. In fact, Lord, we have even said the width power and the guided power test violation. Lord, we have also said about that. Lord, if your Lordship sees, Lord, point R, Lord, in fact, there is a categorical observation, Lord, in Ashoka Kumar Thakur, that, Lord, inclusion of forward caste, Lord, and reservation violates the basic structure of the Constitution. Lord, there is a categorical finding, Lord, by the Constitutional Bench, in fact, Lord, that extracts the Indira Savani 2, Lord, observations also. Lord, in fact, I have, Lord, given data in Annexure C as to how, Lord, this rightful share in government jobs, Lord, is still a distant dream. And, Lord, the persisting rampant discrimination is happening, Lord. If the Lordship sees Annexure C, Lord, from page 15 to 26, Lord, I will only show, Lord, one data, Lord, that is at page number 18. The Lordship can see this data. It is, in fact, is a right to information, Lord, news item, Lord, reflected in Hindu, Lord, at page number 18. The Lordship can see, Lord, what is the percentage of, Lord, the officers, Lord, in OBC concern, Lord, in the government department. In fact, Group A is 14%, Group B is 15%, C is 17%, D is 18%. In fact, Lord, one data also says, you Lordship kindly see, my Lord, page number 16. Not even a single person, my Lord, is in the President's Secretariat, OBC cadre. That is what it says, my Lord, in page number 16. Then, my Lord, your Lordship would kindly see, my Lord, the other arguments where, my Lord, the double reservations and all, I don't want to go, my Lord. In fact, it is not a double reservation. My Lord, open category, my Lord, if they come and compete, my Lord, that is a that cannot be counted as a reservation at all. Lord, my humble submission would be this: 103rd Amendment, Lord, is not a mere violation, but it is an abrogation of the constitutional core values. Then, so far as, Lord, the learned Solicitor General, Lord, submission is concerned, Lord, my learned friend questions as if, Lord, there cannot be any judicial review. Lord, Lord, insofar as the constitutional amendments is concerned, Lord, he would say, unless, Lord, the chair, legs of the chair is broken. Lord, we are demonstrating, Lord, to your Lordship, that, Lord, the edifice of our Constitution, Lord, is built upon and stands on several, Lord, pillars. Remove any one of them, the Constitution collapses. Lord, in fact, if your Lordship sees, Lord, the language of the preamble, that was taken from the resolution itself, Lord, the resolution, your Lordship knows, Lord, it is a resolution adopted on 22/1/1947. Kindly note down, my Lord.
Yes.
That resolution, one of the resolution, clause 5, is equality and equal opportunity. Now, whether that, Lord, can be removed, Lord, this is considered to be a basic human rights. Lord, equality is considered to be a basic human rights. Lord, along with the liberty. Lord, they are essential features of Constitution.
Yes.
Now, my Lord, if this edifice, one of the, Lord, pillar is removed, Lord, what are all, Lord, the edifice of the Constitution, what are the pillars, Lord, I will just name, my Lord, I leave it to your Lordship, Lord. So far as first one is concerned is sovereign democratic republic, then justice, social, economic and political, then liberty of thought, expression and belief, faith and worship, equality of status and opportunity. Now, each one of them, Lord, is important and collectively they assure the way of life to the people and which the Constitution guarantees. Lord, this is the undertaking where, my Lord, the people have come together. Now, today you wanted to remove this. Lord, we have one anomaly, Lord. That is what I wanted to show your Lordship, Lord. In Tamil Nadu, your lordship kindly see Annexure D, my lord. In Tamil Nadu, kindly come to Annexure D. Lord, these backward classes, page number 27, Annexure D. Lord, these backward classes, Lord, have not been still included, Lord, in the union list. Now, what will happen to them? They are the reserved candidates insofar as the state is concerned, but till today, my lord, they have not been given reservations, my lord, insofar as the union list is concerned, and they cannot compete, my lord, in the central government jobs. Now, that is why, my lord, I say, my lord, that inequality still prevails.
Going by the submissions made by the learned counsel, if they happen to be in that EWS category, they will certainly be entitled.
Lord, that is what, Lord, they will say, my lord, that it will go into the EWS category. But if your lordship sees, my lord, that creamy layer also will come into force. Lord,
Creamy layer will also be entitled
Yes.
in the open category of 40%.
yes, Lord, I just pointed out, Lord, what is the
You are right,
difficulty.
but that
Yes.
argument doesn't take us further.
Yes, my lord. Now, my lord, if your lordship sees, my lord, I will skip that, my lord. Now, if your lordship sees this controlling article, I will come to this controlling article. My lord, I was talking about.
Mr. Wilson, you are eating into everybody.
No, my lord, I am not, my lord, still I have 10 minutes more. Yes. Yes. Lord, so far as I'll finish, I'll complete it, Lord.
Yes.
Lord, so far as this 8 lakhs criteria is concerned, Lord, how there is no controlling. Lord, in fact, this honorable court, Lord, has recorded as the events, Lord, how they came out with the office memorandum and how the writ petition, Lord, came before this honorable court challenging that 8 lakhs criteria. Lord, I've said in paragraph G, H, and I. Lord, in fact, Lord, if your lordship sees that 8 lakhs category, page number 28 in 14 different states, I've given that. Lord, they have adopted.
Wilson, these are all facts.
Yes.
We can't get into that.
Yes.
You talked about identity width.
Yes, identity width and Lord, they are, Lord, certainly, Lord, they are, Lord, trying to, Lord, take away, Lord, the identity.
Thank you,
And,
Mr.
and
Wilson.
Lord, the comparison alone, Lord, I've showed to you, Lordship, the comparison.
Plain
That-
facts you can't strike
Yes.
in the constitution.
Greatly obliged, Lord. Lord, but why I'm saying is that, Lord, these things have been gone into, Lord, by the way, this honorable court, Lord, in earlier round of litigations have said that is, Lord, unconstitutional and it affects the basic structure of constitution. Lord, greatly obliged. Only one thing I have to say, my Lord. Your Lordship gave us a good hearing. Lord, this was a pleasant bench. And, my Lord, you treated us with utmost dignity and decorum. Lord, in fact, my Lord, I would even appreciate that there is water to drink and quench our thirst. Greatly obliged.
Thank you.
My lords, I will try and be very, very fast and swift. My lords, this contains my original submissions. The last 4 pages are the rejoinder. Out of that 4 pages, it won't be even 2 pages because argument of the other side, as I believe has been addressed, has been put forward. So if my lords may just come to the end, there is a short rejoinder. It will be probably at page 25, just at the end. Please don't look at the first part. There's only one paragraph in the first part that I will advert to, maybe not even read. My lords have small on the rejoinder. Now, my lords, let me just put on issue by issue as has been urged by the other side, and I have my response there. My lords, as I understand, the learned Attorney General had put a proposition that SC/STs cannot be further subdivided. Now, he refers to Chennaiya in that respect. And he says, therefore, the question of giving EWS to SC/ST categories or for SEBCs does not arise. Now, then he says that if you give it, you cross the 50%. That is the argument that is advanced. Now, my lords, my response to this particular thing is that if we accept this proposition, then in that case, we can't even do a horizontal reservation because in all horizontal reservations, whether it is for women, disabled persons, children, wards of ex-servicemen, etc., it would amount to subdividing them within that. So therefore, I respectfully submit that that proposition does not meet the test. In horizontal reservation, we already have that principle of providing for that, and therefore, to say that it will subdivide may not be correct at all. Now, subdivision is proscribed in Chennaiya, and other judgments following Chennaiya are based on specific caste groups and therefore social. Criteria such as economic weakness are lateral, and there is no rationale to discriminate persons belonging to SCBCs, SCs or STs to not allow their participation. Now, my lords, I would request my lords, and I'm not going into the judgment, my lords have discussed at length the principles of horizontal and vertical reservation in my Lord's judgment in Saurav Yadav. And this, my Lords, will completely, as I put it, comes from that particular principle laid down there. Now, my Lords, let me come to the second argument. The argument that was advanced was that basic structure doctrine, as in Indira Sani 1 and Indira Sani 2, and other judgments is of no relevance because they do not arise in a context of challenge to a constitutional amendment, and no basic structure test could have been employed while dealing with an office memorandum, which was the case in Indira Sani's case. Now, my Lords, a paragraph from Bhim Singh judgment of Justice Y.B. Chandrachud, as it then was read out. First of all, that passage in Bhim Singh that was read out is actually an obiter. Number two, that passage has been subsequently overruled in I.R. Coelho. Yes, it should be taken to have been overruled because, my Lords, what has been said now is that in I.R. Coelho, that even the legislations which are put in the 9th schedule can be tested on the ground for violation of basic structure doctrine. And lastly, taking I.R. Coelho and Madras Bar Association, my Lords have held, particularly also in I.R. Coelho, march of law. So therefore, precedents and law that has been laid down by this court in Indira Sani is a legal position that tests the basic structure doctrine, and it cannot be said that merely because it was decided in a context of an IO, it cannot be said to be applied to the present amendment. I hope, my Lords, I have made myself clear because I am, and my Lords will find this Madras Bar Association paragraph extracted here at page number 18. It's only for the convenience of my Lords. I've extracted that particular paragraph at page number 18. It's the last few sentences of that paragraph, about 10 lines from the bottom, which lays down the structure after recording arguments on both sides. Now, my Lords, therefore, my submission will be that Indira Sani 1 and 2, more particularly 2, is required to be treated as a voice of this court, and there is nothing that warrants overruling of the same, or to say that the guidelines, principles laid down in Indira Sani will not apply to the present amendment merely because that was an OM and here it's an amendment to the Constitution. It's the principle. Now, my Lords, coming to the next. My Lords, it was debated across and also urged by, I believe, by the learned Attorney General that alternate facts and figures cannot invalidate a constitutional amendment, and this court cannot go into facts and figures for the purpose of invalidating. My simple reply to that is, my Lords, it's a very well settled principle that the test of constitutional vices is dependent upon its impact of the state action. It's not based merely on the statement of object. How it impacts finally is the test that my Lords will apply to test the constitutional vices. Now, it will not be merely because it sounds that very well we are providing. So, my Lords, the facts and figures that have been placed before this court will go to show that the impact of this particular state action actually affects the constitutional, it actually affects basic structure doctrine and has an impact which cannot withstand the scrutiny of this court. Now, my Lords, it goes to the very core idea of the equality. That's the principle. Now, my Lords, the learned Solicitor General, and I think this is an important response that we need to consider, and it was also argued by my learned friend Mr. Gopal Shankar Narayan, as I heard it just now. It is suggested that not all incursions into the basic features destroy the basic structure of a constitution. What was said was that the alleged breach of basic structure is not a mere violation unless it is shocking, unconscionable, unscrupulous travesty of quintessence of the Constitution. My Lords, please put it on a test. If this proposition is accepted, then you can go ahead, hit the basic structure of the Constitution chip by chip. Go at it chip by chip. It's not shocking. It is small. You'll have a next one. Now, where this principle comes from, if my Lords may just give me the benefit at page number 21. of my submissions. And my lords, I just have very short ones. I'll finish with this very quickly so that my friends have an opportunity and I don't eat into their time. My lords, the principle comes from what is called page number 21, paragraph 19.1, about third line. The principle that comes here is from the ship of Keyser's paradox in philosophy, offers a relevant parallel. If over a period of time, every single part of a ship is replaced by a new part, at what stage does a ship become a new ship? And therefore, if we accept this proposition, then it's not shocking. It does not affect. It is something very small. And we can go at it slowly, slowly chipping away. We will one day do not know whether the ship is new or it was what was expected by this course on the principle of a basic structure doctrine. So, my lords, I would respectfully submit that a proposition of that has to be taken with utmost caution and utmost restraint, if I may say so. Now, my lords, I come to the next submission, which is made by by a colleague, learned Solicitor General. The primary argument that is said was that the Constitution does not allow for migration of SC/STs, who are the most backward, to vertical reservations created for SEBCs, which are relatively less backward. Now, Constitution can create another zone of affirmative action. This is the argument for EWS category, which exists outside the fold of pre-existing reservation. My lords, I would respectfully submit that first of all, we are not here in this matter and we have not tested that principle of migration of SC/STs into the OBCs. There is no argument that is advanced. It is an area that should be left at the time when there is an issue that is raised. Having said that, in any case, in R.K. Sabharwal and down the line, my lords have recognized that while there is reservation for SC/STs and OBCs, that does not prevent them, whether it is under 16.4 and 16.4a, to move into the general categories if they are so meritorious. Now, if migration there from the reserved category to the general category is permissible, now this is taking back to EWS, which excludes other than classes mentioned in clause 4 and 5 of 15 and 16, apply the same test then there. Please consider it that we are then, people are only, there is a limited, I have already argued it, I am not reiterating. Proportionate reservation is never envisaged under 15 and 16. Only area where proportionate reservation is envisaged, and I think there my learned friend should have pointed out, Mr. Gopal Shankar Narayan, is under 343D and 343D. That is where reservation for scheduled caste, scheduled tribe is proportionate to their population in a constituency, but not under 15. Now, if they are not proportionate, their representation within the reservation class is small and limited. There are many which are left out. There are many which are left out, which may also be eligible under EWS. So therefore, to exclude them by saying that no, there is reservation for them, will be actually failing the test and failing even the test of R.K. Sabharwal, which recognizes that you can be considered under the general category. Now, my lords, very, very quickly, there is an argument that is suggested that exclusion of EWS from EWS is not that of caste, but that of classes who are already receiving the benefit of a special provision. Now, my lords, in this, my reply is, this argument is completely fallacious in my respectful submission. The reservations have been made only for adequate representation and have not been given in proportion to their respective population for each group. Therefore, even within those classes receiving the benefit of reservation, the individuals within the same group, despite being recognized as backward, are unable to receive the benefit. There is therefore no justification advanced to discriminate against them, particularly on an economic criteria, which can only be a lateral consideration. Now, my lords, is just I'm just moving on. Then, my lords, then there is an argument on a breach of 50% limit. My lords, I have in paragraph 24 dealt with it in detail. I am not going to take the time of my learned friend, but here I have only one submission. Learned solicitor, I just one minute. Learned solicitor handed over this particular thing saying that there has been an increase of seats, etc. Please, my lords, we cannot forget the fact, whatever be the number of seats, the principle of reservation as envisaged under 15 will apply, and it is not the case made out by the government. So therefore, it will be 50, 40, whatever percentage will apply to these seats. So there cannot be that we have increased the seats, so therefore we have another 10%. Lastly, my lords, there is no mention under 16 whether there is a job opportunity. This is only in the education sector. This is my last point, and this is on the doctrine of severability. I accept the argument advanced by my learned friend on severability. I believe that if my lords were to uphold this, the deletion of the last portion, other than classes mentioned in clause 4 and 5, will serve the purpose. And this principle, my lords, it may not be reading down principle here. I have dealt with in my submission. It might be on a severability. And here, my lords, I place that judgment of Hiralal Hansora versus Kusum Hansora in the domestic violence case, where my lords applied the same test of severability and deleted the.
Thank you.
My lords, can I have just one thing, just one line, only one line? My lords mentioned about the guardrails for so far as the economic weaker section is concerned. Now, my lords, when the principle is a single criteria of economic backwardness or an economically weaker section, then that cannot be applied differently to different segments of the population. The guardrail is only one, economically weaker. There is no other guardrail. So, my lords, I leave it at that. My lords, I am grateful. We are sorry if we are overshooting our.
I am making 4 points very quickly. I'm trying to finish it, my lord, in 5 minutes. Lord, we had seen, my lord, that the debates, parliamentary debates which are there, which I read out, and even the Constituent Assembly debates which are there, and the provisions, First Amendment, etc., clearly pointed out that as far as the economic criteria was concerned, was something which was excluded. It was not taken into consideration. Actually, I did not mention, but General Austin points out, my lord, that at one point of time when this was being drafted, then the economic criteria came in because the Chief Minister of Madras said that it should be included. But when it ultimately bill went, then the economic criteria was something which was not there. The sum and substance is, my lord, that when you look at the social, educational, and naturally, my lord, the economic criteria comes in. What Justice Jeevan Reddy points out is that the social backwardness, my lord, leads to educational backwardness and then economic backwardness. But assuming we reverse the position, my lord, then in the reversal also, it is not something that economic criteria alone can be there. Now that is something very important. The economic criteria, if we reverse the situation, my lord, as pointed out by Justice Desai, Justice Channaparati, even in that situation, it is necessary that the component of education backwardness and social backwardness, they come in, because they form ultimately, my lord, as we saw the entire debates and discussions in several judgments, really forms, my lord, the equality clause. And that equality clause, my lord, is the basic structure, ultimately drawing at that. And therefore, if you have only the economic criteria, in my humble submission, cannot be the basis of the basis of structure, my lord, which sustains the constitution. So that's not my point number one. The second point is that because the idea ultimately is that you have the equal and unequals, and then you are trying to really see that the unequals strive to not achieve that kind of equality. The second point is, my lord, as far as the circles are concerned, I have little doubt about the circles, because according to me, we cannot put them in, my lord, SC, ST in a smaller circle and then backward classes in the other one and then bring another circle. In my submission, my lord, there is equality, the overall equality, which is one circle. In that circle, we have persons whom we called initially the backward, because SC, ST and backward classes, subsequently it was included because the term which was used was only backward. So within that circle, the idea is that ultimately they strive and achieve the equality. So therefore, my lord, these are two circles which are there, and the outer circle which remains, my lord, outside this 50% as we call it, is a circle which is general in nature. We cannot put it, my lord, that this is a circle and versus the other circle. This is for generally for everybody. you cannot bring in any kind of reservation within that particular circle. If possible, what can be done is, because that is something, not the small circle is governed by 15.4 and 16.4, if you put it not that way. The other circle is 15.1 and 16.1, which is the equality clause read with 14. So in that circle, if you want to do something, what is permissible is the horizontal one. You cannot have vertical reservation in that, because the moment you do it, then what Ambedkar pointed out, that you are virtually negating the entire principle, which even of reservation, because 70-30 example which was given, that you keep on doing it and then the entire principle of reservation, etc. is nullified. Now, my lord, my third point, I think I mentioned this about that you can't have what Learned Attorney General argued, that 50% reserved, and which is one category and 50% is other, and therefore we are not touching that. I don't think we can put it, my lord, as versus something that no, this has been done, and because we have given you everything, therefore we are giving it to other persons. It cannot be. And in one sense, my lord, if you do that, then it becomes caste-based reservation or communal reservation, which has been argued by Professor Verma. Now, my lord, my fourth point is, I am rushing very quickly, my lord. The fourth point is about the creamy layer. Now, my lord, the question is that if we bring in this principle about the SC, ST, OBC, that on the basis of economic criteria, because 8 lakhs limit is there, 8 lakhs limit is here, and therefore you cannot distinguish or differentiate between the persons who are economically weaker. But the difficulty will be if you, as far as the SC, ST are concerned, because this creamy layer limitation doesn't apply to them, then that part has to be resolved. And that is not permissible if you bring a lot of persons here. I hope lordships are followed. That is to say that if you give the benefit, the criteria, economic criteria which is there, the cut of 8 lakhs, which is also creamy layer, and here, their SC, ST are not governed by that. You bring them here, then that particular limit will come, which cannot apply to SC and ST in that sense. The other argument is about Article 21A. That argument has been advanced because the definition includes the SC, ST and backward classes. It's not merely the EWS criteria. Lordships must just note that page in Granville Austin, that is volume 4, 1530. I am not giving the pages, my lord, to Indra Sani and other cases. But I am trying to, my lord, say that shift the position from economic criteria to this one of social backwardness to economic criteria. Ultimately, the essential component of social backwardness, education backwardness should come. Then only, my lord, equality criteria and the basic structure we say will be something. My lord, what we have done is just pass on. Some questions which are put and answers which are in 3 pages. If your lordships will not wish.
Thank you.
Yeah.
Now don't read that, we'll read it.
I am very grateful, my lord. Quickly I summarized, but then I hope I was able.
Yes, Mr. Chauhan.
May I please, my lord?
Who follows after Dr. Chauhan?
Professor Mohan Gopal. My lord, I have only 2 issues which I want to agitate, my lord. First is, my lord, have taken a view that this is a constitutional principle. So the interpretation or the basis has been removed. So I have to see the constitutional philosophy of Article 141, read with Article 145(5) of the Constitution, my lord. As per the scheme of the Constitution, my lord, the precedent value of a judgment of this honorable court is decided, my lord. Whether it is a constitutional provision or a office memorandum or a order, my lord, when my lord have to test it from a different point of view, if my lord finally decides that this doesn't violate basic feature, my lord. So my lord have to respect the larger bench of Indra Sani, my lord, because that principle has to be respected, and there should be discipline. Because my lord, in Nagaraj, when Nagaraj was argued, I have raised this issue, but Nagaraj was not referred to larger bench. Even today, after 16 years of Nagaraj judgment, in 2006, Nagaraj was decided.
In almost all states, there is no reservation in promotion. And only central government, some services reservation promotion is being followed. So this should not happen, my lord, because the discipline, the judicial discipline of president and the bench composition or the hierarchy of the bench, my lord, that should be followed. This is my one argument. The second is, my lord, the learned attorney general has said that the scheduled caste, scheduled tribe are loaded with so many benefits, my lord. So I could find a article, my lord, regarding American context, my lord. Professor Owen Fish, he has written an article, accumulation of disadvantages. So this article basically I want to read for a purpose, my lord, because he has defined that those people who have been historically disadvantaged group, they can only be classified, and their subjugation should be continued, my lord. And otherwise, it has many aspects, my lord, which will take time. So I want to just say that my lord have to see the historical context, my lord, the deprivation, social exclusion, the untouchability. Professor Ravi Verma has tried to say that scheduled caste should be bifurcated. When a president of India from the scheduled caste, he goes to a temple and he is not allowed entry. When they go to another temple, his wife was just pushed, and both the cases, criminal cases are going on for this. So, what is the difference between a scheduled caste who is a laborer and who is a president? So, my lord, have to consider all those aspects in mind, because this is a class of a different nature, and we don't want that this reservation should continue. But there should be some reason by which it could be changed. The reason by which the reservation system could be changed is to emphasize on caste, because the deprivation, the discrimination is because of caste, not because of his economic condition. If the economic condition would have been the basis,
थोड़ी देर बाद आने दो. Yes, go ahead.
if the economic condition would have been the basis, then this type of discrimination would not have been there. And my lord, other aspects I have already argued that social democracy and others. Now I think Professor Mohan Gopal.
Thank you. Who is there now next to?
Mr. Mohan Gopal is
Yes.
being a little awkward because we have all reached into his time also.
So we started with Dr. Mohan Gopal.
Submission, my lord.
Sir, I do not
One
want
short
to
submission to
inconvenience.
make.
No, that's all right. We'll go ahead for, how much time would you require?
Sir, Gopal, other than Mohan, namely Gopal Shankar Narayan, has taken up half an hour of our time unexpectedly. We did not know that. So I have no time left, sir. I want to make, I had a couple of substantive points to make, and there's no time for that. But your time is far more precious than mine.
No. Please, we will try and accommodate. Yes, to the extent possible.
I have only one singular submission to.
Dr. Mohan Gopal,
Yes, sir.
give you half an hour after lunch.
Yes, sir.
After lunch, and that's the last word in the matter.
Yes.
Mr. Kaliswaran, whatever you wish to say, next 5 minutes, sir.
Yes, I can. Can I do it now, my lord?
Yes, right now.
Yes, my submission is only this, Lord. I just wanted to make a rejoinder with
Yes,
respect to this already provided for argument, advanced by the learned Solicitor General and by the learned Attorney General. The already provided for argument, that is to say, that you have already given the 50% is not a valid argument for two reasons. Number one, Lord, as Justice Bhatt was pointing out, the fundamental rights, my lord, are always individualistic, and it is not a class right. Therefore, to say that OBC or SC or ST is given the benefit of reservation as a class is not an answer, my lord, when the fundamental right violation is alleged. Again, my lord, this was dealt with, this fundamentality or the individuality of the fundamental right was specifically dealt with in paragraph 108 of Puttaswamy, 2017, 10 SCC, page 1, at paragraph 108. But one single sentence answers it all. This is the sentence I quote. the individual is the focal point of the constitution because it is in the realization of individual rights that the collective well-being of the community is determined, unquote. If my submission, therefore, Milo, is that if the benefit is given to us as a class, that is not an answer when we allege that in the context of exclusion, our individual fundamental rights are violated. That is the answer to that. Therefore, Milo, I would therefore also say that if in Puttaswamy it was said that if individual is the focal point of constitution, I would respectfully try to place with your lordship that what is focal point is also part of basic feature of the constitution. Therefore, this violation of individual fundamental rights can also be termed as an infringement or as a violence to the basic feature of the constitution. This is my submission on that. Secondly, but very briefly, rather than coining it, but as an equality code, I would respectfully point out that the key test would be to see whether there is discrimination. That is to say, anti-discrimination will be at the core of the basic feature rather than the broader or rather the wider or rather the abstract category of equality code. The question is in the context of exclusion whether there is discrimination or not. But that will alone will answer the question. And lastly, would I just, in conclusion, I want to thank your lordship, Lord, for streamlining it in such a fantastic way. And I am reminded of modulating the whole deliberation in such a fantastic, disciplined way. I am reminded of what the Times said about one of the novels by Gabriel Garcia Marquez. The sentence read like this, quote, "There is not one stale sentence, redundant word, or unfinished thought." Obliged.
Yes, please. I'd like to begin by expressing my deepest gratitude for this extremely valuable opportunity. Sir, with your permission, I will quickly make 3 points by way of rebuttal, and then I will focus on the methodology for determining whether there has been a violation of basic structure, which I derived from Justice Kapadia's Chief Justice's judgment in Nagaraj, where he provides a very wonderful framework for that. And so I'd spend little time on that because I think we need to move towards methodology for deciding how to, what the issue would be. And lastly, sir, I'll come to very quickly to a possible way forwards in terms of where we can move. So with your permission, sir, I'll begin by making 3 short submissions by way of rebuttal. I think a couple of things that have been the theme of the presentation on the side of the union and other respondents has been to characterize the social and educationally backward classes as castes, and to say that reservation of SEBC is casteist reservation. So I want to start, sir, by reading to you very quickly the criteria which are now on the website of the National Commission for Backward Classes for including a community as a backward class. It says, sir, castes and communities. There are, first of all, sir, these criteria divided into 3, as you may know: social, educational, and economic. They have to full any community, any caste or any community, generally considered as socially backward. That's number 1. Number 2, castes and communities which mainly depend on agriculture and or other manual labor for their livelihood and are lacking any significant resource base. Castes and communities which for their livelihood mainly depend on agricultural and or other manual labor for wage and are lacking any significant base. Castes and communities, the women of which, as a general practice, are for their family's livelihood engaged in agricultural and or other manual labor for wage. Castes and communities, the children of which, as a general practice, are for families' livelihood of a supplementing families' low income mainly engaged in agriculture and or manual labor. Castes and communities which in terms of the caste system, not as castes, in terms of the caste system are identified with traditional crafts or traditional or hereditary occupations considered to be lowly or undignified. So this is a stigma, sir. Castes and communities which in terms of the caste system are identified with traditional or hereditary occupations considered to be unclean or stigmatized. Nomadic and semi-nomadic castes and communities, denotified or vimukta jati castes and communities. Caste and this is social, sir. Then this I consider political, although there is no subheading. Caste and communities having no representation or poor representation in the state legislative assembly and or district level panchayat raj institutions during the 10 years preceding the date of the application. The term poor representation may be taken to refer to a caste or community whose presence in the body is less than 25% of its proportion in the population. Educational. Castes and communities whose literacy rate is at least 8% less than the state or district average. Castes and communities of which the proportion of matriculates is at least 20% less than the state, and of which the proportion of graduates is at least 20% less than the state. Economic criteria. To be a socially and educationally backward class, you have to fulfill the following economic criteria. Castes and communities, a significant proportion of whose members reside only in kacha houses. Castes and communities, the share of whose members in number of cases and in extent of agricultural land surrendered under the Agricultural Land Ceiling Act of the state is nil or significantly low. Castes and communities, the share of whose members in state government posts and services of Group A and B, classes 1 and 2, is not equal to the population equivalent proportion of the caste or community. So any caste or any community, any group of people that fulfills these criteria are entitled to be a socially and educationally backward class, which is why, sir, this honorable court very rightly recommended that transgenders be included as an OBC community. Transgenders. The National Commission of Backward Classes has recommended that orphans be included in the list of OBCs. So this category, created by the founding fathers of our constitution, has yielded the desired result. It has become the main category uniting the common people of this country across religion and across caste, across region, across geography, as backward classes fighting for greater representation and a greater share of voice in this country. And as I mentioned last time, sir, every Varna is represented, every religion is represented, every Muslim in Kerala belongs to the backward classes because they really suffer from deprivation. So the first point I want to make very simply, sir, is to rebut this idea that this reservation for communities that fulfill these criteria is being repeatedly vilified as casteist reservation. What is the basis, sir? A caste is entitled to be a class. But casteist mindsets see a class only as a caste because they cannot see anything else other than a caste when they look. So therefore, I think we must recognize the value of creating a uniting category that cuts across various kinds of deprivation, and we must strengthen it. Now, is that being abused? Yes. What is not abused? And that's why the National Commission for Backward Classes rejected that Jat should be made backward classes. And the government, for political reasons, then government went ahead and gave them OBC category. So these mechanisms are working, sir. And I'm the first to say that these criteria must be strictly applied for the objective of giving voice and representation to people who are living in this condition. And they must be reviewed, monitored, and people who are not in these conditions, which frankly bring tears to my eyes, sir, when I read these conditions. We are talking of actual people, that they should have voice and a share. Otherwise, what is the purpose of our having freedom and democracy, sir? But it should be monitored, and it is not. But we should not throw the baby out with the bathwater, sir. That is my first point. Second, very briefly, sir, is this relationship between weakness and backwardness. I want to rebut the idea, sir, that weakness and backwardness are totally opposed to each other. When I saw the three-circle formula that Honorable Justice Butt put forward, what appealed to me was that there was a continuum running across that circle, and that was weakness. Weakness. The word weakness comes from the Proto-German word Weiku, W-A-I-K-U. It means soft. It will yield. No capacity to resist. So if you take Justice Butt's circle, as he said, at the center you have the greatest weakness of SC and ST. Then you radiate out and the weakness is less. The capacity to resist improves. And at the outer end, I would say are residual categories. Then what he said, what Justice Butt said, reflects also very much, according to me, what Dr. Ambedkar also taught, that there are residual categories that may not be captured effectively within these categories of weaknesses. They're not homogeneous. Their types of weaknesses are hugely varied. They practice very unhealthy habits even towards each other. There is massive human suffering in these groups, and to call them homogeneous because they are assumed to be caste does not do justice to that category, sir. So I think we must understand that weakness is a quality, sir. It's a quality of yielding, being soft. Backwardness is a rank. Are you towards the back or are you towards the front? Weakness produces that rank, but you can't. They're not intended to be opposed to each other. You cannot use backwardness to fight weakness or weakness to fight backwardness because they're two categories. And I saw in these three circles, sir, a rank and a recognition of weakness as I saw it myself, and I thought that was quite very helpful. Lastly, sir, my rebuttal point is, please don't divide the joint family, constitutional joint family of social, economic and political, sir. They go together. The rest of the world has just begun to realize that what is social is economic, what is economic is political, what is political is social and economic. They're all different sides of a complex human condition. And so we have moved away, sir, from, in the last 70 years, from measuring poverty simply by looking at consumption and the right to buy food, to multidimensional poverty indicators, where we are looking at various aspects. And we find, sir, that poverty is defined as a multidimensional problem. No less than the IMF said, sir, that it's a multidimensional problem that goes beyond economics, to include, among other things, social, political and cultural issues. This is a recognition that we had in 1950s in our constitution, always speaking of justice, social, economic and political. And to achieve justice, social and political, economic, you cannot just look at economic criteria. So separate from Indira Sawhney, sir. Indira Sawhney expressed the right sentiment. Now, if today you were to offer me the proposition that reservation should be on social criteria alone, I would be the first to oppose it, sir. I will say, don't ignore the economic criteria. Don't ignore the political criteria. If you say reservation should be only on political criteria, I will be the first to oppose it. I'm not against economic criteria, but I'm against single point criteria to determine human suffering and human backwardness. Poverty remains an extremely complex morbidity to recognize. But if we have made any progress, it is to realize the complexity, not to reduce it to 8 acres of land or X amount in the bank. So we've left that behind, and I think India will be shamed in the rest of the world if we still show that that is our approach to understanding human suffering. So these are my three rebuttals, very quickly. I'm aware of the time. Now I want to move to three basic structure violations. We've all focused, and my learned colleagues who are far more able than me and far more knowledgeable than me have very deeply pointed out to many basic structures, although the respondent side has tried to narrow us to only two issues of whether or not economic criteria can be is valid under the constitution, whether there's 50% reservation. But actually, number of submissions have been made on basic structure. But many of these submissions have focused on the exclusion. I want to focus on the inclusion, sir. My real problem is with the inclusion, not with the exclusion. And what is my problem with the inclusion, sir? My problem with the inclusion is that for the first time in our history, being a member of a forward class, socially and educationally forward class, has been made a prerequisite for getting government assistance. If I'm a member of a born as a member of a socially educationally backward class, sir, how do I become a member of a socially and educationally forward class? Never before, sir, in the history of this country, has there been a requirement that to get government assistance, you have to be a member of a socially and educationally forward class. You have to be socially and educationally forward. This is why I think until recently, the idea was to tackle financial weaknesses. Yes, there are genuine cases of financial weaknesses. I myself know one person, sir, who's a member of the royal family of a state, and he was telling me how he grew up in utter poverty, had to eat roots when he was a child. And I told him, I said, yes, you had to do that, and you should never have had to do that. Your suffering is no less or no different than any other child in this country. But you must remember that no door was closed to you by society. No door was closed to you. I know someone else who was very poor from a priestly family because the father and the grandfather decided that they want to serve the temple and be priests and live in that condition. But when the children decided, no, we will study, sir, every door opened for them, sir. Every door opened for them. In school, in college, outside the country, in the best jobs in the country, and their friends, my friends, both of them ended up in top positions in the country. So our problem is with doors being closed by society on us. And that is a problem that can be solved only by forcing those doors to open through a reservation, a set aside such as reservation. Now let me turn to, so my first problem is that this requirement violates the basic structure. And I will come to that in the methodology in more detail, but that's the first. I'm only submitting the three things violate the basic structure. One is this prerequisite that you must belong to a forward class to get EWS is a violation of the basic structure. Number one. Number two, sir, there is a requirement that sorry, sir, I'll just take 1 second. Yes, sir. The second difficulty with the violation of the basic structure is that is about the way 103 amendment treats reservations. Now, I believe reservation is a very dangerous instrument, sir. It's a very dangerous instrument. Because it necessarily involves displacement and discrimination. You're pushing someone out to get a chair, which is why we are before you, sir, because the question is that being done fairly and justly or not? Now, because reservation is a very dangerous instrument, Dr. Ambedkar himself in the Constituent Assembly said, don't apply it to more than 50%. Not because he wanted that to be a rigid criterion to be used to destroy the social and educationally backward classes and the SC, ST, as some of my colleagues may wish to do. But because he realized the danger of reservations, and he wanted more than anything else that every Indian should have equal opportunity. That's what the struggle of the movement always was. So it's a dangerous instrument. So therefore they anchored those reservation, put chains on it so that it will not run out of control. The chain was that you shall be used only for representation. And you shall be used only for representation by backward, for those who are being discriminated against. That instrument, you can do anything else, you can help people in any other way, but this dangerous fellow, don't use him for anything else except to open the doors that society closed on you. You use him as a lever to open those doors and nothing else. Now what 103 does is, sir, it destroys those harnesses on reservation. It says to uplift someone. It doesn't matter whether he has suffered from discrimination or not, but to uplift someone, you can use reservation. It is reservation unbound. If this amendment is approved, in short order, sir, there will be thousands and thousands of programs in this country to give exclusive assistance to various groups of people through reservation. Reservation will be unbound and let loose on this country. So instead of tightening that and making sure that it does not apply except where the truly deserving need representation, we are doing the opposite by universalizing and compartmentalizing reservation. I agree, sir, with you that compartmentalization already exists. It's a problem, sir. Let's not make it worse. When I heard the arguments about compartmentalization, ma'am, my mind went back to 1896. I was never there, but went back to the Supreme Court of the United States in 1896, where they considered a case where a law was enacted by the state of Louisiana that railway compartments, it's ironical that the other side used the word compartment, railway compartments will be reserved by race. One compartment for whites, one compartment for blacks. And if you entered, if a black entered a white compartment, you would be fined and prosecuted. And so some civil rights activists decided to test that law. A man who was partly white, partly black entered the compartment. He was caught, he was prosecuted. He appealed the case. The case went to the United States Supreme Court in a case called Plessy versus Ferguson, 1896. And in that case, the state argued that what I am giving is compartments, separate but equal. Separate but equal was the defense of the state. Everyone, no, I'm not taking your share. You won't take my share. What is your complaint? You're getting your own compartment of the same quality. So the state argued separate but equal. And it was upheld by the US Supreme Court in what has today become one of two most disgraced judgments of that great court. It took until 1954, 60 years and 3 or 4 generations before it was reversed in Board versus Brown of Education. So I was reminded of the arguments that were made in Plessy and Ferguson when we heard an argument from our union that we want separate compartments and no one should complain, just be in separate compartments. So this is a violation of the basic structure idea of unity and integrity and harmony and fraternity of this nation. Fundamental violations, sir. If an imprimatur of the Constitution of the Supreme Court is put on this argument, which has now been openly placed before you, sir, you cannot but take judicial notice of this. The Attorney General of the country has placed before the Supreme Court of the country, we want separate but equal. And it took 60 years for the United States to realize that separate but equal is nothing but separate and unequal. That's what it is in reality. And therefore, sir, compartmentalization and unleashing of reservations, reservation becomes a free agent virus running through society, compartmentalizing everyone. What is the legacy that you will leave us, sir? So these are my limited points, sir. I have about 7 minutes left on the basic structure violations. I move to the last part, sir, methodology. And on methodology, sir, I turn to Justice Kapadia's judgment, sir. Wonderful judgment, as all of you know him, a judge of great clarity and great wisdom. So if you turn to para 22 of the judgment in M. Nagaraj, I don't have the right, I rely on Indian Qanun and all that, sir. So I don't have the right numbers, but it's para 22.
122.
Sorry? It's page 242. Yes. Yes. I'll just read the quotation, sir. The question, because my time is limited, I have only 5 more minutes, sir. The question which arises before us is regarding the nature of the standards of judicial review required to be applied in judging the validity of the constitutional amendments in the context of the doctrine of basic structure. So this is exactly on point, sir. Justice Kapadia is giving us a methodology on how to decide the validity of the constitutional amendment of a constitutional amendment in the context of the doctrine of basic structure. Sir, if I would like to go through, but I may need another 4 or 5 minutes, sir, if you permit me, sir. So, sir, para 23 says the recognition of a basic structure. It's a brilliant analysis, sir. Recognition of a basic structure in the context of amendment provides an insight that there are beyond the words of particular provisions, systematic principles underlying and connecting the provisions of the Constitution. So what is clashing with the basic structure, sir, are the principles underlying the provisions, not the provisions themselves, is what Justice Kapadia is telling us. These principles give coherence to the Constitution and make it an organic whole. These principles are part of constitutional law, even if they are not expressly stated in form of rules. Now, this is a very important and significant limitation to the idea of basic structure, sir. Justice Kapadia is saying that if you want a principle underlying a provision to be part of the basic structure, it has already got to be a part of constitutional law, recognized by courts and binding on the legislature. So that prevents anyone from coming in and putting any random principle as a part of the basic structure by just putting it into the Constitution. So you have to go through a process where there is a law, there are principles that are established by courts, accepted and are binding on the legislature. Then you say, okay, that is the principle by which I will determine the feature, the nature of the provisions. He says the provision acquires its characteristic as a feature from this underlying principles. So it's like saying there's a car. A feature in the car is it has steering wheels and brakes, and it has a radio. These are all features of the car. But some features are essential, like steering wheel and brake, but the radio is not essential. So Justice Kapadia says, I won't read the whole thing, sir. Justice Kapadia says, you look at the provision, you identify the underlying principle, and then from that underlying principle, the provision gets its features. And then you see where that underlying principle fits in the larger scheme of the Constitution, its goal and its scheme, its objects and its scheme. And then see whether it is a radio or a steering in relation to that, into that whole scheme. If it is essential, then you say it is part of the basic structure. That underlying principle is part of the basic structure. And as I said, sir, that gives us the safeguard, a great safeguard, that unless a principle first becomes part of constitutional law, it cannot even be a non-essential feature of the Constitution. It cannot even be a non-essential feature of the Constitution. In my academic work, sir, I have emphasized this, and I have regretted that this has not been developed more to prevent, this is a safeguard to prevent random principles coming in. Now, sir, I will not read, for lack of time, I will not read the rest of the passages, but I'm looking at para 22, para 23, para 25, para 28, and para 37. In 28, Justice Kapadia refers to the working test evolved by Chandrachud J in the election case, in which the learned judge has rightly enunciated with respect that for determining whether a particular feature of the Constitution is a part of its basic structure, one has perforce to examine in each individual case the place of the particular feature in the scheme of the Constitution, its object and purpose, the consequences of its denial on the integrity of the Constitution as a fundamental instrument of the country's governance. But I think Justice Kapadia's unique contribution is to qualify that the principle must be a part of constitutional law already and must be binding on the legislature. Sir, now finally, sir, in the last part, let us apply, sir, to apply this principle very quickly, so there's no time, 15.6 or 16.6. What is the underlying principle of 15.6 and 16.6? The underlying principle is that those who are poor and are socially and educationally forward and therefore deprived of reservation must get reservation. This is the underlying principle. Now, this underlying principle is not an established principle in constitutional law. It is not binding on the legislature. And it is in violent conflict with principles of equality, with the features of the Constitution that already exist to advance its objectives, which have been recognized. I have a list of, I don't have time, but I can go through the cases and the specific basic structure principles they establish. Many of them are in Keshwan Bharati. All of you know that more than I do, so I don't wish to take time on that. If you wish, I can. So therefore, sir, if you apply this principle to this test, you easily come to the conclusion that these three provisions, compartmentalism, the forwardness as a precondition, the quality of forwardness as a precondition to get government assistance. So this can be extended as a general principle to all aspects of life, sir, not just restricted to reservation. And the letting loose reservation in this society without any restriction as a benign welfare activity, like a loan mela, right? Just go and give it. These three specific parts of 15.6 and 16.6, I think, very violently oppose the violently oppose the or conflict with the basic structure. Last part, sir. Last part. What's the way forward, sir? What's the way forward? Looking at it from the point of view of the court, I think there are two ways forward, sir. Three ways forward. One is to strike it down. The other is to sustain it as it is. But I think there's a third way forward, sir, which does not involve reading down, does not involve severance, and can solve these by basic structure conflicts in one stroke, sir. What is that, sir? And that is to take now. So this amendment is before you in two versions, sir. Now, after these 2 weeks of discussion, it's there in two versions. One version I will call the constitutionalist version, sir. The constitutionalist version. The other version I'll call the forward class version, sir. So the forward class version. Now, I'll take two parts of 15.6, 16.6 and see how it is interpreted in these two versions, sir. You take the phrase economically weaker section. In the forward class version, it is interpreted as socially and educationally forward classes with a creamy layer exclusion, and other than 15.4, 16.4 classes. But in the constitutionalist version, sir, you can read economically weaker sections because of its reference to economic weakness, not financial weakness, and to poverty. The entire justification of the union has been premised on poverty alleviation, sir. And poverty alleviation, as I said earlier, is a much broader context than financial incapacity. You can read it as below poverty line, BPL, with priority to the neediest, irrespective of caste and creed, sir. Send a strong signal to this country, sir, that we've reached a stage where we recognize poverty without respect to caste and creed. This is an opportunity to do that. So the constitutionalist interpretation of this phrase would be BPL with priority to the neediest, irrespective of caste and creed. Now, the more difficult one, the second phrase, other than the classes mentioned in clauses 4 and 5. There, the forward class interpretation is, this is like a yellow star that the Nazis gave to Jews. You stick it on you, and wherever you go, you are a Jew. So if you, it's a yellow star is a social identity, sir. I would argue the status of OBC and SC/ST are only relevant when you are you're claiming or getting that reservation. If you're not in the room for claiming benefits, you're a human being, sir. Not a yellow star. You're a human being. If I'm an OBC in one state, there is a particular community, I don't wish to name it, it's scheduled caste in Karnataka, it is OBC in Maharashtra. Now, does that person change, sir? Morph from OBC into SC/ST when he crosses the border? No, he's just a human being. But his entitlements and claims may change. So socially and educationally forward class interpretation are converting class into caste and attaching OBC, SC/ST to all of us like a caste that stays with you. They cannot see us as human beings anymore except as OBC. So we reject that approach, sir, and take a constitutionalist approach. What is that constitutional approach, sir? It is, we see this other than the classes mentioned in clause 4 and 5 as meaning that the eligibility criteria for forming the sections in Articles 15.6 and 16.6 shall be other than the eligibility criteria for forming the classes in Articles 15.4, 15.5 and 16.4. For example, in 16.4, 16.5, you have to be backward. So you cannot use that eligibility criteria in 15.6, 16.6. You can use poverty. You can use poverty. So So other than, sir, the Constitution is always at the level of criteria, sir, not at the level of identifying human beings. All these are criteria, whether it's EWS or OBC, SC, ST. The Constitution sets out criteria, broad criteria. So why are we reading the Constitution as referring to people and putting a yellow star on them? And why don't we refer to this as criteria? Now the question is, sir, last question is, this will not, as the bench had observed.
So what are you saying
Yes.
that other than means descriptive?
Other than refers to the criteria, not to the people. The criteria shall be other than.
Criteria means it has to be descriptive. See, criteria, we can call it, it's a matter of semantics.
Yes.
Other than is, you have 4 socially and educationally backward.
Yes.
Now, other than can mean 2 things. The way we have understood so far is exclusionary.
Yes.
The other way to read, perhaps, is that this is descriptive. In addition to, the category 4, we have this category.
What has been described in 4 and 5.
What is described? In addition to that, we have this. Therefore, in that event, there is no exclusion.
Yes.
Then you have you can call it a silo, you can call it a separate container, where everybody competes on the basis of poverty.
No, sir, as you can read it in any manner, that is not a manner that is referring to human beings. Human beings. So, for example, criteria for sports persons is different from criteria for persons with disabilities. So, if you want to get horizontal reservations under either, you can be a scheduled caste woman who's a sports person and is disabled, and you have to deal with 4 sets of criteria. And there is nothing in interlocking reservation that says you cannot have multiple eligibility. So
what Justice Jeevan Reddy said, interlocking
reservations. So what I'm saying, sir, is that we read these as we ensure that there is no overlap. Now we can attribute rationality in saying that backward classes and weaker sections are very closely interrelated. They're 2 sides of the same coin. Therefore, all the more reason to ensure that the eligibility criteria are distinct and with intelligible differentia. So here, for example, no need to put this criteria on what your stigma is or your social status is. You can just concentrate on the deprivation. This MPI, so the multi-dimensional poverty index criteria. You can do that. And sorry, sir, forgive me. The last point I want to say, sir, is that yes, this may mean that the political intention of providing a separate compartment for a particular group may not be achieved, but that is not the concern, sir, of a court. And that will never be the concern of a court. First, this will not be the first time that a political intent has been frustrated by what Justice K.K. Matthew, I forget the judgment, beautifully once called the need for all constitutional provisions to be in fraternity with each other. So when this, whatever the political intent may have been, once 16.6 and 15.6 enters the house of the Constitution, it acquires all the characteristics of all its friends in the Constitution, sir. 21, 19, 14, 16. They're all one big friendly family, sir. And they have to live in harmony together. And so this interpretation, where we say that other than means that the criteria shall be distinct, eligibility criteria shall be distinct to avoid an overlap, will allow you, sir, to keep this going without running into the letting reservation run loose, disconnecting reservation from backwardness or poverty, and without.
They are disrupting the harmony. This entire process is due in the alternative suggested way forward. It's required to be maybe is taken up only when if we come to a conclusion that these amendments, 103rd Amendment, whatever is provided is not otherwise living in harmony with the other provisions of equality wherever they are. If they are otherwise, they could exist in harmony, they could exist.
Of course. But it all depends on what interpretation we give it, sir. These are not provisions which are neutral. So as I said, there are two interpretations you can give it. One interpretation will allow them to live in harmony, sir. But another interpretation will not. Will not. There's no doubt about it, sir. Thank you so much, sir. I'm deeply,
With my lord permission, I am seeking only
deeply
30
grateful to
seconds.
you.
I wish to
Deeply
point out
grateful
only
to you.
two things, my lord, 30 seconds, not more than 30.
Your data.
Yes, my lord.
We have seen that. data.
Yes, my lord. I want to point out on two things, my lord. I want to point out on data. In Jammu Kashmir, 34% OBC people and 2% reservation in Jammu Kashmir on the OBC category. And that matter pending before the alternate bench in item 105, my lord. And state of Madhya Pradesh, SC, ST, OBC people are 89%, and OBC people, admittedly, 52% population in OBC category, and reservation only 14%. And my lord, the ratio is a very important one. I want to read only one paragraph. My lord, this define the.
Get into that issue, that whether the ratio-wise or proportionate representation.
Yes.
What are you hinting at, sir?
So, my lord, these people are not adequately represented in the government sector in anywhere, my lord. That's the reason we want to point out.
According to you, supposing, for instance, in a given state, scheduled tribes are more than what is the percentage of reservation meant for them. This is what you are hinting.
My lord, I want to point out this, my lord. In 52% population in Madhya Pradesh, only 13% people are working in the government and PSU, my lord. So this is the actual situation in the ground level, and they are and 20% reservation given. And
What we are focusing on, and again you would request, sir, how this particular way of looking at the things would help us in arriving at a conclusion whether this amendment will disturb the basic structure or disturb the basic features or not. Individual cases or individual layout or spread of the persons or the percentage of persons getting into employment, not getting into employment, maybe because of variety of factors, sir.
yes, I want to just point out, reservation is the tool to give an adequate representation all corner of the society.
And what you are now trying to say is that there is inadequate representation for certain sections of the society.
Yes.
Understood. But that is not something that we are called upon to decide. We are called upon to decide completely different dimension of the problem. But we can't, by our decision, make some kind of, adequate representation for those who are inadequately represented. What we are called upon to decide is what is the explanation, what is the content, whether it violates basic structure or not. Correct? Your data is not going to help us in that direction.
Only one thing, my lord. If this amendment is upheld, then again, my lord, we are excluded in this amendment. OBC SC is not included. So we are excluded in 10%.
Have argued well.
I'm sorry.
So please rest.
I want to just point out, we are already placed the data, my lord, so kindly.
That's all right, sir. You have told us at least 4 times.
I'm sorry, my lord.
We have understood.
I'll take 20 seconds, Lord Sir, just to apprise that the criteria of 8 lakh limit is pending before court number 2. So
That's all
in case Lordship is going to upheld or whichever way, it should not be decided on the 8 lakh limit.
Okay.
Here files the IA, that is notice.
In this matter, your lordship made a beginning with advanced written submission.
Mr. Sharan, we
Timeline.
want your again assistance on the point, because by the time we have come to the close of this particular matter, we started with say 1 unit, today we are 20 units, correct? We want you to again put that in concise form. If you and Mr. Kanu Agarwal, if you can actually, we can bank on your services, please do that in next 3 or 4 days time.
Because we'll do it in the next 3-4 days. Just one suggestion I had, from the experience we have gained here. Because your lordships may consider advanced timelines and advanced written submission as a part of practice directions for constitution bench matters generally. Because the bar is also learning. Because in this matter you are learning.
No, it should be not just constitution bench matters, every 3-judge bench matters.
Because the beginning can be made because we are also learning, your lordships, so despite the advance, we were still submitting.
Your lordships, the notes that learned AG and SGN has submit, your lordships will give us till Friday to put it to the.
What? We
The
can
notes,
gather.
your lordships, because now there's a flood of material which is coming.
Okay, very well.
By Friday, we'll submit our notes.
Okay. Now,
You
please,
already
no more.
submitted your notes.
No more.
Because your lordships, there's a new.
That's
flood of
all right, that's
information
all
which
right,
has
but
come.
it's okay. You are appearing for certain interveners now. To what extent do we keep on
No, your
entertaining?
lordships, the learned AG and learned SG also.
Maybe so.
Yes, your lordship. So we'll submit it by Friday as well.
Please don't do that. Please don't do that.
Lordships,
See,
because
we don't want to be confronted with new points.
there
Let's be
won't
very
be
clear.
new
So
points.
we are sealing everything now, except where it specifically permitted.
It's only
That's
for,
all. No,
yes,
I don't-
it's only for lordship's assistance if lordships wants it in
please
a
let it be
proper
so.
fashion.
That's unfair because if you come up
We
with
have
some
given you
points, the
sufficient
buttons
time to make your
There's
own.
no new I'm just submitting, there'll be no new information. We are going to
But
just put
then
it in a
if it is
manageable.
not in you, please leave it to us. We will
Very well,
take care.
as your lordship does that.
रोको मत हमें टोको मत हमें आगे बढ़ते जाना है जय भीम का नारा लगाना है जय भीम का नारा लगाना है जय भीम
अंबेडकर मिशन चैनल आर्थिक समस्या से गुजर रहा है। अगर आप बहुजन समाज में बाबा साहेब अंबेडकर और तथागत बुद्ध की विचारधारा को अधिक से अधिक लोगों तक पहुंचाना चाहते हैं तो हमें आर्थिक सहयोग प्रदान करें ताकि हम अपने चैनल के माध्यम से देश विदेश में समता, बंधुता, एकता और संवैधानिक अधिकारों को ज्यादा से ज्यादा लोगों तक पहुंचा सकें। आप अपनी सहायता राशि नीचे लिखे खाते में जमा करा सकते हैं। खाता धारक गौतम रत्ना, खाता संख्या 3169576865 IFSC कोड SBIN 0060336 बैंक भारतीय स्टेट बैंक। आप हमारे बैंक खाते का विवरण स्क्रीन पर भी देख सकते हैं।
हेलो फ्रेंड्स,
हाय एवरीवन,
वेलकम टू रोज सिनेमा।
रोज सिनेमा पे आपका स्वागत है,
जहां आपको देखने को मिलेगा
होस्टिंग,
एक्शन,
कॉमेडी, सस्पेंस, स्टिंग,
अनटोल्ड स्टोरी।
हमारे चैनल रोज सिनेमा को
लाइक,
शेयर
एंड सब्सक्राइब करना
मत भूलिएगा।
भूलिए।
मैं गौतम रत्ना आपका बहुजन फिल्म प्रोडक्शन में स्वागत करता हूं और आप हमारे प्रोडक्शन हाउस के अंदर अपना कैरियर बना सकते हैं एज ए फिल्म डायरेक्टर, एज ए प्रोड्यूसर एंड एक्टर एंड एक्ट्रेस एंड एडिटर एंड सिनेमाटोग्राफर ऑल्सो। अगर आपको फिल्म से रिलेटेड कुछ भी प्रोजेक्ट आपको बनवाना है तो हमारे पास में पूरा सेटअप है जिसमें फिल्म कैमरा है, शूटिंग लाइट्स है और एडिटिंग है। सारा A to Z एक ही जगह पर आपको हमारे यहाँ पर मिल जाएगा। तो दोस्तों आप हमें कांटेक्ट कर सकते हैं हमारे नंबर्स पर 9810085714 और 8510005714। हमारे वेबसाइट पे विजिट कर सकते हैं www.filmserviceindia.com और हमें मेल भी कर सकते हैं gautamfilmsproduction@gmail.com पर। धन्यवाद।